Yes.
It's a fishery matter. Point is very, one point is involved. My lord, some difficulties are there. Can it be taken up on Tuesday next? 18th,
Not Tuesday, Monday or Wednesday.
Monday,
Monday. Item number
52, 53.
52.
You will have to go for a hearing,
Oh, 52, 53.
admission hearing,
It has come for final hearing, I think.
final hearing.
52, 53, based on Monday.
Point is, well, if one gets a fishery, whether he can tender for another fishery.
Okay.
Monday, man.
On the payment terms of the very senior council.
May I please also?
Yes.
Item number 39, Lordship. I've taken consent from the council of the petitioner. May be taken on 21st, Lordship, Wednesday.
21st. Item number
39, Lordship. Admission.
39. Okay, with consent from the other side. So, SC Kerala understanding of GST place for adjournment. Here is a note list on 21. I need the clarification in the income tax matter. I have not been able to.
Today I am giving. Today.
Yes.
May I please, your lordship, I beg to mention item number 12.
Or not between me.
May not like to take up this matter.
Item number 12. This is the matter with before any other bench without me. Yes.
Deeply,
Item 12.
deeply obliged.
May I please, your lordship? Lordship, I had filed an IA for implementation.
Item number.
No, lordship, I have filed an IA for implementation. It may be listed because
Give it to the court master. All praise for listing, please give it to the court master. You may have to make some adjustments for 1 or 2 days.
any date would be.
May I please, your lordship? My lord, I beg to mention item number 73, my lord, of supplementary list, my lord.
73.
My lord.
Yes.
This case not been steps service is complete, my lord. So the matter may kindly fixed for admission.
Mr. ARD counsel for the petitioner submits that the case is ready as regards service. Instead of the matter will listed in the admission column the next week.
I want to mention one read petition, 7328.
Must not pay for listing, give it to the court.
Make please, Your Lordship. But I have a prayer for listing and read petition unlisted manner. But the issue is, my lord, there is a demolition order issued by the GMD. And in a very peculiar fact, my lord, I am the occupier. The register owner, they have not submitted the documents and they want this demolition to be happened. Hello.
But give notice to the other side also.
I'll make
Oh, sorry, I did not. see
Lordship,
it.
item number 69, 70, 71. These are in the supplement list, lordship. These are matter for final disposal.
Yes.
So actually, I wanted it. It will cause inconvenience because it will take little bit of time, not very much. My preference was tomorrow, but they have some difficulty. Could it be taken up on Friday, lordship?
So, this
Or else on Tuesday, lordship. On a hearing day, it will be more convenient. If it is convenient on Friday also, I have no difficulty.
Tuesday. Okay, Tuesday. Both sides are duly represented on the made by Mr. D. Saigal and the Advocate General for this case. List on so and so.
26.
69, 70, 71.
71. Urgency is there because lordship,
Can it be tomorrow?
these are seeds of agriculture department. The season is almost over. Or lordship, if fixing on Friday also, we can take a chance on that day.
Friday may not be more convenient.
Friday.
Friday will be more convenient, my lord. My senior had some difficulty.
Okay, then Friday. Friday will be
At 2, my lord.
16. 16. Okay.
Highly obliged.
Obliged.
May I please honor? WBC 156/223 is a land acquisition matter. It was last.
Where since how much time you are here? Since how much time you are in this court today? How much time you have spent in court today since morning?
Last 10 minutes.
Last 10 minutes. You did not hear what I was saying for listing. So today I am refusing. I am refusing if you are not attending. If you are not attending in court, I am not attending your petition. Yes,
But,
yes,
but item number 67, it's a supplementary admission matter, my lord. It's a tender matter, otherwise affidavit we have filed, they have also filed a reply. It's ready, my lord, tender regarding supply of liquid nitrogen, which is the main, my lord, the lifeline of that entire project. Some urgency is there, my lord. I pray for taking up this matter, if possibly,
we'll try to take up, let me finish the motions first.
lodging. Or if not today, tomorrow or Tuesday, my lord, a fixed date, my lord.
Let it
My
reach.
friend is there, my lord. He is for the petitioner.
Okay.
Lordship.
Supplementary cause list, item number 54, delivery of order.
In all these three, item 54, 55, and 56,
Lordship.
since the NDPS matter, I could not record my satisfaction of, they are not guilty of offense, and therefore bill are rejected. It's in, some corrections are there. in- Yes.
So it is done.
Daily list item number 1 for motion.
May it please your lordship. Lordship, in this arbitration petition, some inadvertent clerical error has cropped up after its filing. So I pray before your lordship.
After filing,
After filing, lordship.
errors are cropped up.
During drafting, lordship,
Very-
during drafting.
Or during drafting.
During drafting, the
No, it's okay, but I was surprised that even after filing, it can crop up.
no lordship, during drafting, lordship. So I pray lordship may kindly allow us to withdraw with the liberty to file a
Okay.
case.
Upon instructions, Mr.
AK Boro, lordship.
A.K. Boro, counsel for the petitioner, seeks to withdraw this petition as there are typographical errors in the petition with liberty to file again. Standing counsel for GMDA is present. Matter is dismissed on withdrawal with liberty to approach again.
Item number 2,
Matter regarding non-payment of bill. Non-payment of bill. Yeah, your name? D. Malaka. Yes. For the petitioner, non-payment of bill. Who is appearing? You are appearing?
Lordship, this item number 2, Lordship. Lordship, I am appearing for respond number 2 and 5, Lordship.
Mr. Arkady Chaudhary,
I'm for one, lordship.
item number 2,
Lordship, I am appearing for respondent number 1.
Yes. Yes. Compensation.
Yes, lordship.
Lordship, this matter has been transferred from Itanagar bench, Lordship. We have to receive our records also, Lordship.
We have also not taken the brief from the council engaged from the Itanagar. So if lordship may issue notice, then we.
Okay. But I think you'll have to take an administrative approval for filing it here.
My lord, in this, the similar matters, my lord,
Hmm.
there was a direction for, we have not filed it here, my lord. This was filed in the Itanagar bench. It has been transmitted here, my lord, as per the directions of the Honorable Chief Justice. Because there are other similar matters pending.
But there's absolutely no note put up here.
My lord, we were informed there, my lord. All the
No,
matters
no,
pertaining to
you see,
this,
I'm not questioning your statement,
my lord.
but
Well, there was a blanket order passed by the Chief Justice, my lord. Therefore, the registry in Itanagar bench has transmitted all those matters to Guwahati, my lord, to the principal seat.
no, I'm not disbelieving you.
My lord, my
But the problem is that without an administrative note,
Yes, yes.
I am not aware of it.
My. The registry should have.
Hmm.
At least the registry in
Okay.
Itanagar bench should have.
You should have put up a note.
My lord.
Okay, heard Mr. P.D. Nair, learned counsel for the petitioner, Mr. R.K.D. Chaudhary, learned ASGI appearing for respondent number 1, and Mr. A. Chandran, learned additional senior government advocate appearing for
2 and 5.
respondent numbers 2 and,
Five.
sorry, state of Arunachal Pradesh, appearing for respondent numbers 2 and 5. The learned counsel for the petitioner has submitted that this matter was filed before the Itanagar bench. However, it has been transferred to the principal seat. Next one. The issue notice of motion, returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Runnet State and Department, CGC and additional senior government advocate for state of Arunachal Pradesh in course of the day. Next one, the petitioner shall take steps within 2 days for service of notice on respondent numbers. Over the respondent numbers.
My lord, NHPC, my lord, I also do not have the brief, my lord.
Okay, 3 and 4 by registered post with ADs. First of, in addition, notice shall be served on the respondent number 4 by way of thusly by routing the process through the registry of the court, and upon service and affidavit of service shall be filed prior to the next date of listing. Next, in the meanwhile, the registry shall put up a note about the regarding the transfer of this matter from Itanagar bench to the principal seat. That's for the start of weeks.
My lord, may I be permitted to take steps within 2 weeks, my lord? Because I have the brief I have not received from Itanagar.
Oh, acha. Okay, copies in, no, then I'll have to fix after 6
After
weeks.
6 weeks.
After 6 weeks, 2 weeks time.
My lord, I have a soft copy of the. I have a soft copy of the letter from the registry, my lord, for transmission.
It's okay, they'll put up a note. I'm not disputing you, but things might be said right.
Deeply obliged.
Much obliged.
Number 3.
Yes, item 3. It was. Not this. Yes.
Matter regarding non-payment of bill also.
Oh, acha, okay.
Is admitted.
The Malaka for the petitioner. Mr. D. Nath, standing counsel for PWD.
1, 1, 3, 4, and 5. Sir.
PWD 1, 3, 4, and 5.
Also,
And Ms.
straight in.
G. Hazarika, standing counsel for Revenue Department.
It's everything common here.
Notice steps. Notice extra copies and
That's-
penalty shall not be barred for the respondent authority to examine the claim of the petitioner to make payment if found due.
Or
That is a loss.
Yes.
Of the present petition with very limited preamble for this court, Lord. Petitioner may have a representation before the authority, my lord, but the lease period is going to be completed on 30th June. And this period of the list is going to be completed by this month, my lord, and I made to a representation on 1st January, my lord, all the river water dried up for inquiry, and next recent on 27 May for extension, my lord. Though, my lord, the tender for the period.
This tender, I am not interfering, but you'll get the, will give you liberty to
representation in the
seek for,
meantime, yes, my lord.
to seek, what you call, what is it called, remission.
Yes, my lord.
Okay. Mr. P. K. Tegal, I'm counsel for the petitioner. And Mr. S. Datar, and standing counsel for PNRD department appearing for respondent numbers 1, 2, 4 and 5. No, sorry, 4 and 6. And Ms. M. Burman and the government advocate appearing for respondent number 3. Next paragraph. The case of the petitioner is that during the lease period of the South Aminir Char,
Moinal Diwani,
Mohinul Diwani. Where is-
Aminar sir, Fakir Chand, Ali Parghat.
It's okay. Where will the where is that? As a para 2,
Yes,
page 4. Huh?
yes.
This name is there. During the page of lease of so and so. Comma. The river water had dried up, for which the ferry service had to be discontinued. And accordingly, the petitioner claims to have suffered loss and has submitted a representation dated 27/5/2023 for extension of the lease period, which would expire on 30/6/2023. Full stop. The petitioner apprehensions that the respondent authorities may float a tender for the said ghat again. Has this repetition under Article 226 of the Constitution over here. Next paragraph. Issue notice returnable. Notice giving notice of the prayer for interim review returnable in 4 weeks. Requisite extra copies of the repetition we served on the learned government advocate and departmental counsel in course of the day. Petitioner shall take steps within 2 days for service of notice on respondent number 5 by registered post as well as by Dasti, routing the process to the registry of the court. And upon service and every of service. Next paragraph. The pendency of this petition shall not be a bar. For the, who is the authority? Mr. Datta?
Yep.
Who will decide this?
Deputy.
Director of Panchayat or Commissioner? Turn your speaker.
Commissioner of Panchayat.
Okay. For the Commissioner of Panchayat and Rural Development Department, within bracket respond number 1, to dispose of the representation of the petition.
Right. Date of this.
My lord, respondent number 2 is regional director, my lord. But director is not, no post is director is there, my lord. So commissioner and number 1 commissioner and secretary is also not a post here in the committee.
First, at the outset, the standing council for the PNRD department has submitted that there is no post with nomenclatures secretary, commissioner from secretary to the government of Assam,
As well as director of Panchayat.
fisheries department, as well as within bracket respond number 1, as well as director of fisheries.
Panchayat.
Sorry, director of Panchayat and Rural Development Department within bracket respond number 2. So the petitioner shall, the learned counsel with the petitioner shall take note of the same and do the needful. That we just added, rest will be same. Okay,
All right.
It's possible for filing.
just 1 minute. Okay, after some time.
6.
Please, Lordship. Lordship, as per NIT dated 10/5/21, issued by the Batodara Anshalik Panchayat Lordship, the petitioner and others submit their tender for settlement of Balishatra weekly market for the year of 2021 and 22 Lordship. And thereafter, the petitioner offered to be spent 91 lakhs 1,000 per year, which was the highest bid Lordship. The first chart
Yes,
and
sir.
highest
It
bidder
is
was
only
2,000.
return of understanding.
My lord.
It is only return of understanding.
Yes, I'll take instruction, my lord.
Okay.
Notice my go, my lord.
Mr.
MS Mondal.
MS Mandal, counsel for the petitioner, and Mr. S. Datta, standing counsel for the Panchayat and Rural Development Department, appearing for all the
All
respondents.
the responses.
Next, agreed by non-refund of the honest money amounting to rupees
69,300.
69,300. The present petition has been filed in Article 226 of the Constitution of India. You should notice returnable in 4 weeks. Extra copies in course of the day. Pendency of the petition shall not be a bar for the respondent authorities to examine the claim of the petitioner and make refund if the petition is found due to is found receivable. Is entitled to refund of the earnest money. List after 4 weeks.
7.
May please. The issue is regarding non-payment.
Non-payment. Mr. P. Hazarika, counsel for the petitioner. Mr. Ms. M. Burman, the government advocate, appearing for respondent numbers.
One is
One.
represented.
1, 4 and 5.
Not 1 and 2 I am paying now.
Okay. So 3,
A early is there.
huh?
Pending council is there, my lord. A early.
Yeah, okay. So you will be for 4 and 5.
4 and 5.
Then Mr. for number 1 and 2, you rate first, Mr.
Yes.
P. Nayak, standing counsel for Revenue Finance Department, appearing for respondent numbers 1 and 2. Mr. A. Ali, standing counsel for respondent number 3. And Ms. M. Burman, the government advocate, appearing for respondent number 4 and 5. Agree by non-payment of the contractual bill amounting to rupees 8,16,548. The present petition has been filed in Article 226 of the Constitution. Extra copies, of course, no notice, extra copies. Pendency shall not be a bar for the which authority?
Deputy Commissioner.
Commissioner.
Gwalior.
Deputy Commissioner Gwalior to examine the claim of the petitioner and to release payment if found due.
Okay.
8.
May I please your lordship? Lord, limited period is for more than 7 months. My application for mutation is pending before the circle officer. And my lord, it has not been disposed of, my lord. So my submission, lordship, is that let them dispose it as per law, whether they accept, allow it or they reject it, my lord. They have been sitting on it for more than 7 months, my lord. And I'm a builder, my lord. There are projects that I have planned for the land.
No, but there is an appellate authority. Have you moved the appellate authority?
I have been, lordship, formally I have not moved, but my lord, I have approached the officials.
No, because you see, these are notified services. If they don't do it, there is an appeal under
Lordship,
the.
lordship,
Will permit you to move that.
lordship.
Unnecessary in the High Court, there will be more delay.
No, my lord, I only pray for a direction that whatever they do, let them dispose it within a time period, whether they allow it or they reject it.
No, you see, under the notified service, they have 1 month to do. Otherwise, you can approach the appellate authority. Appellate authority will dispose it of within a month.
Lordship.
There will be otherwise, what you call fine and other things are there. It will be easier for you.
Lordship.
Mr. A. Sharma, I'm counsel for the petitioner. And Ms. M. Burman, and the government advocate, appearing for respondent numbers.
Copy was served on us, my lord.
It's okay.
Name
2 and
is
3. 2 and 3.
Prabhu.
And Ms. P.R. Mohanty, on the standing counsel for Revenue Department, appearing for respondent number 1. The petitioner claims that he is a builder and had purchased a particular plot of land and had applied for mutation.
On 11/10/2022.
On 11/10/2022, but there is no progress in the matter. Despite representation submitted by the petitioner. The next paragraph. The matter relating to mutation is covered by the, what is that act?
Right. to
Notified
Service. Some right to public service. Act.
Assam Right to Public Service Act, 2012,
13.
12, 12, 12. Which provides for a time-bound disposal of the application for mutation. Moreover, the appellate authority has also been constituted if notified services are not made available to citizens. Therefore, instead of keeping the matter pending, the court is inclined to close this writ petition with liberty to the petitioner to move the notified appellate authority.
For the deputy commissioner.
I, the Deputy Commissioner,
Yes.
Kamrup Metro Guwahati.
Yes.
Because the petitioner is permitted to also produce a certified copy of this order before the appellate authority for time-bound decision on the pair permutation. With the aforesaid observation, this petition is put in.
Yes, exactly. Obliged, ma'am.
Obliged.
9.
May I please, your lordship?
Yes,
In this case, your lordship, the husband, father of the petitioner, your lordship, had expired due to road traffic accident under the jurisdiction of Patasar Police Station.
have you made a statement that you have not applied for motor accident claims tribunal?
No, lordship.
Then you file that affidavit.
Lordship, I want to provide a order, lordship, passed by the Justice Mutual Grant. Lordship, at page 10, lordship. Highlighted portion, middle. Page 10, your lordship.
Unless I read the previous paragraphs, I don't read the last paragraph.
Lordship, page 10, got it? Here,
Heard Mr.
SI account.
SI Akan done counsel to the petitioner. So the, and Ms. M. Burman and government advocate appearing for respondent numbers
3 to 6, my lord.
3 to 6. Prevailing disaster, Ms. P.R. Mohanty and its standing counsel for respondent number 1. Mr. V. Govil and its standing counsel for respondent number 2. Next one. The petitioner claims that the husband of petitioner number 1, petitioner's petitioner and father of petitioner's number, petitioner numbers 2 and 3. While riding through NH-31, suffered an accident as he was hit by a passenger car bearing registration number AS01 AN 6372. date 17/1/2019. And he expired on 21/1/2019 and made an application on 27/2022 for seeking ex gratia payment in terms of notification dated 15/11/2014 issued by the Revenue and Disaster Management Department within bracket Relief and Rehabilitation Branch bracket close, Government of Assam, bearing number RR/33/2014/66 dated 15/11/2014. And in support of his submissions and to project that the said payment is unconnected with with claim to be made under Motor Vehicles Act 1988. Next paragraph. Considered the considered the decision of this court dated 4/5/2019, passed in WPC 2100 of 2019. Gunalata, GUNALATA Das versus the state of Assam and others, and other connected cases. Full stop. However, the court is of the considered opinion that as the petitioner has approached this writ court, it is the duty of the petitioner to disclose all necessary facts. Full stop. Although there is no dispute that the claim for compensation is unconnected with claims under the Motor Vehicles Act, yet it is the duty of the petitioner to disclose correct state of affairs and facts. First of, therefore, the petitioner is directed to file an affidavit to bring on record as to whether the petitioner has approached the MSCT tribunal and the status of the case. First of, the decision cited by the Learned Counsel of the petitioner is kept as a part of the record. List how many days you will file that affidavit?
1 week.
Within a week. List in the motion column thereafter.
Last week.
Then
May I please have a seat?
yes,
Matter relating to diversion of scheme under Jal Jeevan Mission, my lord. In a Gram Sabha, my lord, a scheme of 5 scheme has been selected, your lordship, and thereafter proposal has been sent.
okay, I'll issue a notice.
My lord, in this regard, my simple prayer, humble prayer is that, my lord, instead of issuing notice, otherwise, my lord, without any interim, this matter will in future will become infractor. There is a complaint filed by the president of the Gram Panchayat before the deputy commissioner, who is the head of the district Jal Jeevan Mission, my lord. So my
No, you see, without knowing, I'm not disposing of a writ petition at motion stage. It leads to multiplication of. I'll give a direction that they will consider, but I'm not disposing it
only
off.
my prayer is that, my lord, the deputy commissioner will verify the.
We'll direct him to verify, but I'm not disposing at the motion stage.
And otherwise, my lord, if there is no interim, my lord, then the place wherein the scheme has been now preliminary work has been done, my lord, the scheme will be completed, my lord. And in this regard, we
I'll ask him to do it. Mr.
Then
MAI
protection will be
Hussain,
given,
counsel for the, no, I'm not predicting. Mr. MAI Hussain, Learned Counsel for the petitioner. And Mr. For CEC is appearing. Yes, yeah.
Hearing for respondent number 1, 2, and 3.
Your name?
Peace Varghese.
Peace Varghese, Learned Counsel appearing on behalf of
SK Medhi.
Mr. SK Medhi. CGC. Appearing for respondent numbers 1, 2, and 3. Miss. Over there. Director Drinking Water Sanitation will be appearing. 1, 2, and 3 you are appearing. Okay. 4 is Commissioner Secretary Panchayat PNRD. Mr. S. Datta and as standing counsel for PNRD department.
In my copy, my lord, 3 is the Panchayat.
It's okay. There's typing error. He has corrected it here.
Maybe.
Do the correction, Mr. Hussain, in his copy also. Respond number.
I will correct it.
Respond number 4.
4, 6, 8. 4 to 1 over here. 5. 5 over. 4 over here.
Only 4, I think.
PNID is the 4, my lord.
Only 4.
Only four.
And also there, my lord,
4 and 13.
13.
Okay, 4 and 13. Who are others?
Lordship, I am appearing for the PhD department, Lordship. Respond number 5.
Oh, okay.
Seven.
And Mr. Anand Das.
Arago. I am for water resource department. Respondent number 6, 8, and 25.
Okay, then Mr. R. Gogoi first. Mr. R. Gogoi, standing counsel for PHE department, appearing for respondent numbers
Respond number 5,
5,
7, and 9.
5, 7, and 9. And Mr. Anand Das, the standing counsel for water resource department.
For 6, 8, and 12.
Respondent number 6, 8,
And 12, Lordship.
and 12. And Ms. M. Burman, the government advocate, appearing for respondent number 10. The case of the petitioner is that the land of the petitioner was selected by the Bor Chapuri, BORCHAPURI, Gaon Panchayat, by holding a Gaon Sabha meeting on 2/10/2021 for the purpose of construction of community water purification plant under Jal Jeevan Mission, which was meant for village Bhaja Khaiti, BHAJAKHAITY. First of the petitioner did the preliminary took the preliminary steps of executing an affidavit and to donate the land for the purpose of the scheme. First of, however, it is alleged that the executive engineer, Public Health Engineering Department, Dhing Subdivision, had his respondent number,
He responded most 11 in the Lordship.
Mr. Hussain,
11 in Lordship.
12, my lord.
12.
No, my lord, I'm sorry, it's 11.
Within the respondent 11.
Respond number 11.
Had
Lordship.
diverted the scheme from village Bhaja Khaiti to village Bor Chapuri, BORCHAPURI, without any Gaon Sabha resolution. First off, additional claims that he has made representation before the Deputy Commissioner Morigaon, which has not been attended to. First off, it is submitted that there is every likelihood that the project would be implemented in another village, which would deprive the petitioner and the other villages of their rights. Thanks. You should notice a motion returnable in. We'll make it 2 weeks. 2 weeks. Requisite extra copies of the petition be served on the state and departmental council in course of the day. So the petitioner shall take steps by tomorrow for service of notice on respondent number 14 by registered post with AD, and in addition, notice will be served on the said respondent by Thus, by routing the process to the registry of the court and upon service, an affidavit of service shall be filed prior to the next day of listing. Next paragraph. Taking note of the nature of grievance raised by the petitioner. The court is as an interim measure, the court is inclined to provide that the pendency of this writ petition shall not be a bar for the Deputy Commissioner Morigaon to consider and dispose of the representation of the petitioner dated 31/3/2023 and 8/5/2023. Next paragraph. The petitioner is permitted to produce a certified copy of this order before the respondent number 10 to bring the order to the notice of the said authority.
Only one clarification, my lord. In 31/3/2023 and 8/5/2023, the complaints were given by the president and member of Borsapuri Ansolik Panchayat. Under which
Okay,
Kham Panchayat, my lord.
not of the petitioner, representation that is also by
President and member of Borsapuri Kham Panchayat. Under which
Bor-
this scheme is
okay, Borchapuri Gaon Panchayat.
not only one, all pinpoint has been changed, my lord. And one another clarification, my lord. The Kham Panchayat is exponent number 13, my lord. It was president. Whether it is accepted by the my lord.
No, president will not accept.
It is registered for them and my lord. Register for them.
Okay, 13 also. Okay, notice to 13 also. Not by Mr. Dutta. 13 and 14. Okay.
Obliged, my lord. And I will correct the in by hand, madam.
Here it is corrected, you do a correction there.
All correct, madam.
Otherwise, there will be miscommunication.
I will do.
Non-appearance and call for the petitioner. However, Ms. G. Hazarika, Standing Council appears for respondent number 1. Mr. D. Gogoi, Standing Council for respondent number 2. The government, Ms. M. Burman, government advocate appearing for respondent number 3, 4, and 5. Next one. The petitioner claims that his son, Aminul Islam, AMI, Annual Islam, died in a road traffic accident on 18/1/2014, for which Bogota PS case number 164 of 2014, under section 279/338/304 capital A IPC was registered. Petitioner claims ex gratia as per notification dated 24/4/2007 and obligor notification dated 15/11/2014, for which he applied before the Deputy Commissioner Borpeta on 7/4/2022, which has not been attended. Next.
May I point out one thing, my lord?
Yes.
In petitioner's case, my lord, that accident took place on 18/1/2014. So probably the notification of 15/11/14 would not apply, my lord. It is into 24/4/2007 will apply in his case,
And or he says, he's making both the prayer. If you want to give it to them,
my lord.
or if you say that he will be entitled to under the new scheme, then you give it under the new scheme. So, there's no statement made in this writ petition as to whether any MSCT claim was preferred by the petitioner. First of all, in a writ petition, notwithstanding that the claim for ex gratia is not connected with MSCT claim, but it is the duty of the petitioner to disclose correct state of facts. Hence, the petitioner shall file an affidavit to bring on record as to whether any MSCT claim was referred by him and the status of the said case by way of an affidavit. Listed in the motion column after a week.
Necessary 5% affidavit.
Supplementary cause is 57.
After,
Hello, I believe the matter may be passed over for a time being, my lord. I think 57.
Timing,
My lord, this before eyes on legs, my lord.
this, what do you call, this is that.
Bus terminal method.
Bus stand. Okay, opposite.
It's like that.
58.
This is that 4 heart into 2.
My lord.
Okay, let him come.
Hello.
After some time.
Well,
59.
Yeah, please, Your Lordship. This is a matter relating to the respondent.
What the
I have the
instruction?
instructions, my lord. There were objections from certain quarters, my lord, including the petitioners, my lord. Subsequent to which the authorities have already dismantled the disputed towers and they've been installed at a different location altogether.
But still now the work is going on.
You file an affidavit, give it to her, she will have to take instructions.
Lordship, till the time we will be protected.
No, they've already withdrawn.
Okay.
Your repetition should be dismissed, in fact. They've already dismantled their line. So there's no cause of action remaining, because since you are,
But,
since you
but,
are.
just have to get the instruction.
Her Miss J. Paul, learned counsel for the petitioner, is pursuant to order dated 9/6/2023, Mr. B. Chaudhary, learned standing counsel for APDCL, has procured has received an instructions dated 9/6/2023, which is produced before the court, wherein the concerned subdivision engineer, Demo Electrical Subdivision, Demo, APDCL, has informed the Assistant General Manager, Law, APDCL, to the effect that on complaints being made by several landowners, the APDCL representatives have agreed to allow the Swargadeo, SWARGADEO, SIU-K-PHA, multi-specialty hospital through the by utilizing the existing right of way within bracket ROW of APDCL. Full stop. From the said letter, it also appears that all the existing, no, all the newly erected electricity poles which were erected over the disputed corridor of the land of the Patadars has already been dismantled and lifted out by the contractor and re-erected adjacent to the existing 33 kV demo feeder line as directed by the district administration. Hence, comment appears that the cause of action for the writ petition does not survive. So therefore, the court is inclined to permit the nonetheless, that a notice returnable in 4 weeks be issued. The petitioner shall, the land council for the petition shall provide requisite extra copies of the writ petition to the Learned Standing Council for the APDCL in course of the day. Next, brother. The respondent shall file an affidavit to bring on record their stand. You just say one more thing. In the event any land, any electricity line is set up on the Pata land of the petitioners, the same will be subject to for the orders that may be passed by this court. If they have elected, you can withdraw the petition, take instruction and withdraw it.
Yes.
Instructions are written.
60.
List of 4 weeks. Yes, you have implemented the parties.
Made Willers, my lord.
You have implemented
Last
the parties.
Friday, the lordship is already made up your mind, my lord, that the petition would not lie. Now, my lord, humorously, after change the weather, there will be some change in your lordship's thinking also. So, my lord, here, my lord, why I am saying that this without jurisdiction, that the play I have taken. The lordship kindly come to the provision of the act, the Compensation Act.
Employees compensation.
Yes. A list of books has been given. Section 2, my lord, 1D.
Yes.
Definition. Who can claim, my lord? Must be dependent. Dependent means any of the following relatives of deceased workman, namely a widow, his own widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother. If wholly dependent on the earning of the workman at the time of his death, a son of a daughter who has attained the age of 18 years and who is informed. If wholly or in part dependent on the earning of the workman at the time of his death, a widower, a parent other than a widow mother. So they will have to plead in the petition, my lord. Whether they come within the purview of this. In fact, my lord, it was a case of, my lord, electricity short circuit. And the matter was settled by them on their own, my lord. Lord, when they come to first, my lord, there was an FIR, final report was given. Then FIR was accepted by the court. Then your lord got page 30, 30. After 4 years, they come and claim, filing application on section 22. Page 30, my lord.
Yes.
Most respectively, they inform the police to the officers are Dagaon police outpost. Most respectively, it is stated that today on 25/12/2013, I have received an acknowledgement of an amount of 41,000 only at the Dagaon police outpost from one Jalaluddin. Jalaluddin is the police here, my lord. Let's show him so and sign this acknowledgement in good health and sound mind in presence of the witnesses mentioned. And second, this petition number 2, sorry, my lord, the claimant number 2, page 31. They knew it was electricity accident. That's why they set the matter, my lord, long back in 2013 itself. 25/12/2013. Now, after 4 years, they make a claim by filing the application in page 48 on 3/1/2016. Is an afterthought. And this order, my lord, was passed. You also kindly come to the first order passed by the tribunal, my lord, commissioner, is page 51. 9/9/2019.
Yes.
My lord, this order was not assigned in this court, my lord. This order was assigned in this court by a very person, my lord. I have obtained the copy. And this honorable court entertained that. And matter was demanded because that order was passed ex parte, my lord, giving the same amount of 10 lakhs to compositely, my lord, to two parties. And they have even, my lord, suppressed the fact that they had received the settlement matter long before 2013, receiving the amount of 41,000 each and claiming 4 lakhs each. And this court, my lord, because that was ex parte order, remanded the matter, my lord. And the senior counsel, my lord, Mr. B.C. Das moved that petition, my lord. Petition number 428 of 2020.
Yes.
After there was same order, my lord, except quoting, my lord, mentioning the witnesses, same order, implement order passed, my lord, at page 113 on 13/3/2023. Under 13. There were a lot of evidence, my lord, lot of pleadings, my lord, nothing was considered. Same, a verbatim same order, except saying that as per direction of High Court in WBC number 20, so FLA filed this petition along with the copy of the judgment to accept the petition and to dispose of the same as per law. Accordingly, what WS was given, then the evidence was taken out. Next para. The claimant side examined 3 witnesses. As schedule 1, 2, and 3, and were duly crossed by the OP. The OP also adduced 3 witnesses. DW 1, 2, and 3. One is my VDP secretary, he is independent witness, and was duly crossed by the claimant. During the process of examination and cross examination, the fact of death of the employees, namely so Sabri Islam, Jalaluddin, in his pistol and death in the firing within the premises of the employer was established beyond doubt. This is wrong. Our evidence totally different, and evidence of the VDP secretary is also different. It was electrocution, my lord, short circuit. That fact is not discussion, not taken into consideration. And same amount is fixed, my lord, holding that. Both of them died during the course of employment in firing of pistol premises. Hence, the judgment of instant case stated so is appealed. The earlier order he appeals without going thoroughly through the evidence adduced in the court. There are 60 witnesses. So, my lord, there may be alternative remedy. Alternative remedy must be efficacious and effective for me also. The one who makes the appeal. Now, let's kindly come to page section 30 of the act. It is very harsh law, my lord, enacted into 1923. And mother, living mother is excluded. I don't know why. Section 30, my lord. Yes, my lord. Section 30. Appeal. Has lots of my lord. An appeal shall lie to the High Court from the following order of a commissioner. An order awarding a compensation as lump sum, whether by way of redemption or half monthly payment or otherwise, or disallowing a claim in full or in part or for the lump sum. Then, my lord, kindly skip that and come to, my lord. The entire amount has to be paid, my lord, before I come to the appeal. And they are at liberty to take away the money. What is the guarantee, my lord? That I will because case is good.
You missed out the chance, Mr. Mr. Sharma.
Yes.
You have missed out a chance. You were there for 5 years. You did not amend the law. I'll have to respect you. No, I'll have to respect you for what you have done. You have not amended the law, and therefore I have to respect you.
Time on 3,000 internet and obsolete works.
No, that is okay. But what I'm trying to say is that I just making it in a light tone, not to be not to be misconstructed.
Yes.
But you see, we have to respect the legislature of what they have done.
No, of course, my lord.
So
my lord,
it is law.
First, my lord, the claimant must establish that she is a mother, living mother. She is not a widow. That has not been done. Leading is very direct. Therefore, there is claiming to be employed. They were not employed. On that day, my lord, fateful night, they had guests in their house. There was marriage in their house, so they.
No, ultimately, Mr. Sharma, what we boil down to is, you see, I use the words which I am told Mr. Kalimuddin, most respected lawyer of his times, had said. You see, I dismiss the writ petition and give you a right of appeal. Against that right of appeal, there is every likelihood that you can move the constitution bench and have the law altered, because you say L. Chandra Kumar did what? It says that against the order of a tribunal, you can approach the writ court, and therefore writ is permissible against orders of certain tribunals. But here, when there is a statutory appeal, I can't say that section 30 will not be invoked just because award is to be satisfied. Because then I'll have to touch each and every law. No, you see, under labor laws, there is a requirement that there should be a pre-deposit of the dues of the labor. I have to interfere there also. Any law which says make a deposit.
I am not asking for interference now.
No, you see, but there will be a fallout of my order. In CPC, it says when there is a money decree, then 50% of the award must be deposited.
Yes.
In Arbitration Act, it is a requirement of law that once an award is passed, in an appeal, you make a pre-deposit. In SURFACE, there's a requirement to make a deposit before you file an appeal. So therefore, with my one stroke of pen, I had interfered with so many laws
No, my lord, I am not on that. What I am on, my lord, like the last time your lordship did, demanding matter to consider, reconsider.
But red court doesn't have the power. It has been done. I will make no comment on what has been done, but not in a red court. You have to move this court in what you call appeal.
That is of course there one, but my lord, appeal may lie, but may I cite my one and listen to court.
Yes,
Nice.
please. Why not?
I give in the my December, paragraph 9 of the. And 185 December, paragraph 9 of the, my lord, Supreme Court decision. 61,
2000.
1961, Supreme Court, IN 961 Supreme Court, 1506, para 9. There also appeal line, my lord. It was a case under Tariff Act, 1934.
Yes.
Constitutional bench decision, my lord. The earlier decision Civil Code 1954 has been quoted, my lord. In 1950 and 54. We see considerable force in the argument of the landed Solicitor General. We must, however, point out that the rule that the party who applies for the issue of a high privilege suit before and he approaches the
Sharma.
court have
Some-
exhausted other remedies.
Yes.
Other remedies open to him under the law. He is not one who is barred the jurisdiction of the High Court to entertain the petition or to deal with it, but he is rather a rule which courts have laid down for the exercise of their discretion. The law on this matter has been enunciated in several decisions of this court, but it is sufficient to refer to two cases in Union of India versus T.R. Verma, 1958 and AIR 1957 SC. It is quoted there, madam. It is well settled that when an alternative remedy and equality efficacious remedy is open to a litigant, he should be required to pursue that remedy and not invoke the special jurisdiction of the court to issue a verdict. It is.
You see, this was rightly passed. You see, in this, the facts of this case was
Yes, madam.
that pen was imported.
Yes.
And this pen contained parts of silver and gold in the nib. And therefore, the tariff was invoked for gold and silver.
Yes.
And that was challenged before the High Court. And the Supreme Court says that, well, what happens if the nib of the nib of the pen is studded with diamond? It will not make the pen whole as a diamond.
Yes.
And therefore, it interfered that it's a question of tariff which can be decided effectively in the red court.
Yes.
But here in this,
That is my on fact. On the law point matter, whether alternative remedy would bar coming to the court. That was the aspect here.
can I decide a writ petition on the basis of
No, I
the
am
facts alone?
on the point of jurisdiction. But there is lack of jurisdiction or the pleading is such that apparently and patently, my lord, it doesn't show that they have pleaded the case. That yes, they are the dependent as per section 2. On that only. Your lordship will hear me.
You don't, that point you have never cross-examined, that he's not the, he's not the parents. You look, your evidence is there.
No, they have said mother. They have
It's
said
okay,
mother.
but there is no cross-examination.
No, my lord, since they have admitted their mother, living mother, not widow. Not widow mother, living mother. So whether that would entitle them.
Where is your cross-examination? You are,
On
you
that
see,
point, my lord, since the fact is already there. On the admitted fact, my lord, I
so
need a cross-examination.
therefore in a
On
writ
the
petition,
admitted fact, my lord, I need
Mr.
a
Sharma, you are proposing that in a writ petition, I evaluate the evidence and then say that the evidence which was undebatted in cross-examination,
No, I'm not done there.
then
I am just simply, my lord, saying that whether that the commissioner had the jurisdiction to attend the petition. That's all. Not appreciating the evidence or not evaluating the evidence, nothing. Whether the petition under section 22 would lie or not.
it would lie.
If the calamity, the dependent is not the dependent as desired by law, could it be maintainable.
Yes, it has been interpreted. Now it has been interpreted that you see, earlier that was the married daughters were not what you call entitled to any claim. Now there's been interpretation that any person
No,
would be entitled to maintain a claim.
Yes, there your lordship is after hearing the matter on married day, your lordship decided and that judgment has come out. But here your lordship has not decided yet whether the mother whose husbands are alive are entitled or not. That is the only point I am pointing. And here, my lord, there is no question of appreciating the evidence because it is admitted fact they are the mother, both are mothers. On that count only. Let the my lord, commission decide that point, only that point, nothing. The lordship will not interfere now at this stage.
Okay, I'll decide it. I'll decide in this writ petition.
Yes.
Now. Heard Mr. R.P. Sharma, learned senior counsel, assisted by
Ankita Devkar.
Ms. Ankita Ganga, counsel for the petitioner. And Mr. B. Chaudhary, learned standing counsel for the
Respondent number
APDCL as respondent number 1.
2, my lords.
Sorry, 1 and 2.
Not 1, my lords, my.
What's that? 2. And Ms. M. Burman, learned government advocate appearing for respondent number 1. In view of the order that is proposed to be passed, issuance of notice on respondent number 3, 4 and 5 is dispensed with. Stop. The petitioner has challenged the judgment and order dated 9/9/2019 passed by the commission.
No, my lord, 13/3/2020. Subsequent 13/3/2020. 9/9 is simply quoted by him. On the basis, the second was 13/3/2023.
3/2023 passed by the Commissioner, Employees Compensation Nagaon in NEC case number 1 of 2017. Give a dash, Hamida Khatun and others.
No, only my lord, one, my submission will be not required.
I'll record, don't worry.
Yes, the evidence
Don't
and
worry.
everything.
I'll
Yeah.
record it.
That was not considered.
Versus Jalaluddin. Next one. At the outset, the court had pointed out before the pointed out to the learned senior counsel for the petitioner that against orders and judgments passed by the employees, commissioner, employees compensation, an appeal would lie under section 30 of the Employees Compensation Act, 1923. Full stop. However, the learned senior counsel for the petitioner has submitted that the petitioner is only assailing the jurisdiction of the commissioner, workmen's compensation, to entertain the claim petition as the respondent number 4, who is the claimant. No,
There are two, my lord, jointly filed petition.
okay, 3 and 4.
Fingers.
3 and 4. Uh, 3 and 4. We're not the dependents of the deceased. Next one. It is also submitted that earlier in point of time, the petitioner had assailed the ex parte award dated 9/9/2019, passed in NEC case number 1 of 2017 by filing a writ petition under Article 226 of the Constitution of India, which was registered as WPC 428 of 2020. And this court, by entertaining the writ petition, allowed the petitioner to file an application under Order 9, Rule 13 CPC, read with Rule 41 of the Workmen Compensation Rule, 1924, against the judgment dated, against the award dated 9/9/2019, passed in NEC case number 1 of 2017. Hence, it is submitted that the present writ petitions would be maintainable. And in support of his submissions, reliance is placed on the case of A.V. Venkateswaran, VENKATESWARAN, Collector of Customs, Bombay, versus Ramchand RAM CHND, Sobraj, SOBHRAJ, Wadhwani, WADH AR 1961 SC 1506, as well as Raman Shyam Company versus State of Haryana and others, AR 1985 SC 1147, on the point that existence of alternative remedy would not be a bar for entertaining a writ petition. Postpone. Next, as next, it is submitted that in the claim petition, the respondent numbers 3 and 4 were the claimants before the Commissioner of Workmen's Compensation had made a statement. Where is that statement?
Page 158. 158 one. Page 48 SHG.
Where is that statement? Which para?
Which one, madam?
No, the statement that she is not a dependent.
No, not even. They are the mothers. Paragraph 1. Dear son,
Okay.
Sariful Insurance.
In the claim petition filed before the Commissioner Employees Compensation, Nagaon, a statement is made by the petitioners in paragraph 1 that that their respective son, namely Sariful SARIFUL Islam and Hifzur HIFZUR Rahman, were employees within bracket labor of respondent number 1. Accordingly, it is submitted that a mother would not be entitled to claim compensation in view
Whose husband is living? Whose husband is living?
whose husband is living would not cannot be a claimant in a claim petition under employees compensation. And in this regard, reference is made
Section 2.
to section 2 within bracket
1D.
1 within bracket B. Of the Employees Compensation Act. Full stop. This is the only point urged by the learned senior
One
counsel.
more thing, on execution for my, since your electrical execution order, electricity connected, which I pleaded in my evidence also. The compulsory act would not lie, you would not want to tell, because there was a pleading and all evidence.
Moreover, it is submitted that as it was a
Paragraph 75,
accident
Yes,
involving electricity,
page 75.
comma, the claim under employees compensation will not be maintainable. These are the only 2 points urged by the learned senior counsel to the petitioner. Next paragraph. It would be relevant to quote the provision of section 2 within bracket D of the Employees Compensation Act. Full stop. On a plain reading of the provisions of section 2(1)D quoted above, comma, it would be apparent from clause B of subsection clause Roman 3 within bracket B that a parent other than a widowed mother would be a dependent. Full stop. Therefore, comma, notwithstanding that the father of the deceased and or the husband of the respondent numbers 3 and 4 are alive, comma, statutorily a parent would also include the mother of the deceased. Full stop. Therefore, comma, the first point raised by the learned counsel for the senior counsel for the petitioner is answered in the affirmative in light of section 2 within bracket 1 within bracket D within bracket Roman 3 within bracket D, that the respondent numbers 3 and 4 being a parent would fall within the meaning of dependent. Next paragraph. Insofar as the second point is concerned, that it was a case of electricity accident.
Page 75, my lord.
Where is the cross examination of the PW on that point? Where is your cross examination?
Yes.
Was there?
Lordship, kindly come to my examination sheet.
No, your examination I'm not interested. You must, to take a defense, you must first demolish the cross examination of the.
Yes, I
claimant.
have that, my lord.
Where is that? I did not find it.
Yes, my lord. Those are next.
No, it's okay, but I did not find that part of cross examination.
There is not there, of course.
Is it the second plea which is taken that there was an electricity accident which caused the fire. The same thing factual matrix is left best to be decided in statutory appeal, which is provided for under section 30 of the Employees Compensation Act, as determination of the same would require examination of the documents and the evidence in details, which this court exercising power under Article 226 of the Constitution of India would not venture to do as prescribed. However, this court has the jurisdiction to entertain an appeal under section 30 of the Employees Compensation Act, and therefore there would be no bar for the petitioner to approach this court in an appropriate jurisdiction. Next paragraph. The learned senior counsel for the petitioner had referred to the on the case of A.V. Venkateswaran with Venkat Supra. In the said case, the factual matrix was to the was that pen was imported with certain parts like nib, clip, and cap were plated with gold or silver, and accordingly, the authorities charged the imported pen with the tariff under item 61 within bracket 8. First of the petition was dismissed by the High Court, and the Supreme Court of India had held that as the imported pen fell within the category of fountain pens within bracket complete, inverted comma, fountain pen within bracket complete, and item 45 of the 3, comma, it was held that the repetition could have been entertainable. Full stop. In the case of Ram and Shyam Company, the appellant before the Supreme Court of India had a was allowed a mining lease And on the mining lease being granted to the to the and despite the and despite the bid of the petitioner being the highest, comma, the state settle the contract with the respondent number 4. Full stop. Under such an circumstance, comma, before the Supreme Court of India, comma, when offers were made by the respective parties, there was a huge increase in the minimum rate offered by the respective contesting lease contesting parties, and therefore the Supreme Court of India had observed that repetition would lie in such a circumstances when the state so as to ensure that the best price and larger revenue would come into the coffers of the state administration. And accordingly, it was held that it was open to the appellant to file a writ petition as there was political interference in the settlement of the mining lease. First of all, both these circumstances do not exist in the present case in hand. Because when a claim is made, when an award is made by the workman compensation, Commissioner Workman Compensation, comma, the court cannot examine the correctness of the award under jurisdiction, under its jurisdiction under Article 226 of the Constitution of India. And therefore, this is not a case where, despite alternative remedy being available, writ petition could be maintainable with regard to the challenge to the award passed by the Commissioner, Workmen's Compensation. Therefore, next paragraph, therefore, the issue which could have been decided under Article 226 of the Constitution of India regarding the maintainability of the claim at the instance of the mother of the deceased is held in affirmative, and insofar as the challenge to the award as well as the issue regarding whether death occurred due to electricity, what is it called? Electricity?
Electrical accident.
Electrical accident is left to be decided in appellate jurisdiction under section 30 of the Employees Compensation Act, and therefore adjudication of the other issues raised in the writ petition is refused. First of all, writ petition stands disposed of in light of the observations made herein before. Next one, the registry shall transmit an order of this court to the Commissioner, Employees Compensation, Nagaon, to make this order a part of the record.
But this will not bar the appeal.
No, I have not said that. I have already said that you can avail that. Therefore, there will not be a bar for the petitioner to appropriate against the award in an appropriate manner.
Limitation may come for a few days. That I'll file it.
Okay, next one. This writ petition was filed on 7/6/2023. Therefore, the petition shall be entitled to exclusion of time from 7/6/2023 till all the past today, as time spent in the court. Under different jurisdiction. Under writ jurisdiction.
There's a caveat in this one.
My learned senior friend appears for the caveat only. That will be discharged.
Give it discharge. Mr. Ayub Chaudhary, Senior Counsel, assisted by Mr. Archer. For the petition. Yes,
May it please your Lordship. This matter pertains to settlement of a mining contract area. Well, the petitioner has filed this writ petition challenging his illegal rejection of the technical bid as well as the letter of intent issued to the private respondent. I would directly come to the grounds of rejection. My lord, Lordship would find it in page 92, my lord. 92 of the writ. Now the font is very small, my lord, I'm sorry. Page 92. Serial number 3, my lord. It's the name of the Mohol, the MMCA. My lords would find that serial at column number 4, my lords. NKD B4 Khudnabari mining contract area, and the rejection, my lords.
yes.
Few columns, my lords, to the right. Closed technical bid. Lordship has it.
Serial number 3,
Serial number 3, my lords.
closed technical rejection.
Rejected. And there are 5 grounds if your lordship is not. My lord.
Yes.
Yes, sir. The first is PF return not submitted. Second, ESIC return not submitted. Third, Bakijai certificate not submitted. Fourth, bid document digitally not signed. 5, facts and affidavit not submitted as per format, hence rejected. So, my lords, this grounds the petitioner contends is highly illegal and arbitrary, my lord. Let us test this grounds, my lord, one by one. Lordship would take up the first 2 grounds. It says PF not submitted and ESIC return not submitted. My lords would come to the bid document, my lords. My lords would directly come to page 47. It is an admitted fact that PF and ESIC is required as per the bid document. Page 47, my lords. It's clause 5.2.9, my lords, page 47.
Yes.
Highest bidder is expected to take measures for welfare of labor working on mines. Therefore, each bidder has to provide scanned copies of PF registration of the company, firm, individual, along with monthly details for the last 2 years at the time of submission of bid. B, each bidder has to provide scanned ESIC registration of the company, so and so, along with monthly details for the last 2 years at the time of submission of the bid. Now, it is an eligibility criteria, my lord, as per the bid document. My lords would then come to, my lords, page 48 for a moment. If my lords turn the page.
Just a moment.
My lords.
Yes, after page 47, which page?
Page 48, my lord. My lord has seen, my lord, that providing ESIC and PF registration is the eligibility criteria as per the bid document. Now, my lord would come to page 48 for a moment. My lord. Clauses 7.8 and 7.9 at the bottom.
Index one.
7.8 and 7.9. May I read, my lord?
Yes.
7.8, my lords, the state government competent authority shall endeavor to provide clarification and such further information as it may, in its sole discretion, consider appropriate for facilitating a fair, transparent, and competitive tender process. The next clause. The state government competent authority may also, on its own motion, if deemed necessary, issue interpretations and clarifications to all bidders. All clarifications and interpretations issued by the state government competent authority shall be deemed to be a part of the bidding document. Now, this is legal fiction, my lords. There's a deeming provision that if there's a clarification, it will be deemed to be a part of the bidding document. Provided, however, that any non-written clarification so and so provided the government or its employee representatives in any manner whatsoever shall not in any way or manner be binding on the state government competent authority. Now, my lords, will come to page 87 for a moment, my lord. Along with the bid document, the competent authority or the responding forest department had provided a checklist, my lords. Which in my humble submission amounts to a clarification, page 87. My lord. Lordship would peruse point number 13 and 14. It says EPF certificate, bracket, if not available, same has to be provided within 1 month of being chosen as a successful bidder as per clause so and so. 14, ESIC certificate, if not available, same has to be provided within 1 month being chosen as successful bidder as per clause so and so. Now, the clarification clearly states that in case I am chosen to be the highest bidder, I'll get a time of 1 month to submit the ESIC and PF registration. And naturally so, my lords, because the auction is not just open for companies, firms, it is also open for individuals. And my lord is aware that an individual, because it's not a condition, it's not a sign qua non, my lords, that every individual has to have a PF registration or ESIC registration, because it is only when there are 20 or more employees working under a person, he has to register under PF. Similarly, 10 or more under ESIC. So naturally, my lord, this clarification was issued, which is a part of the bid document. So insofar as the first 2 points are concerned, my lords, EPF and ESIC, the bid of the petitioner was illegally, my lords, rejected. Now I'll come to the reason why it was illegally rejected. I've been told, my lords, only one bidder was made qualified and they settled the bid in a post-haste manner, my lords. Within 1 day, they made the settlement. My lords, would come to the next rejection, my lords, the next point. My lord, 3 is Bakijai certificate not submitted. Three and 5 can be dealt at the
Just
same time.
I'll just take a break and come.
My
back.
lord, sure, sir. My lord, we kindly turn to page 92, my lord, again.
Yes, I'm there.
My lord, 1 and 2 I have dealt with, my lord.
Ah.
Yes, and yes,
Number 3 is Bakijai certificate.
Number 3 is Bakijai and
Yes.
number 5, my lord, both can be taken up together, my lord. 5 is facts and affidavit not submitted as per format, hence rejected.
Yes.
My lord, insofar as the Bakijai certificate is concerned, my lord, the eligibility condition, my lord, would directly come to the bid document. Clause 5 is the eligibility condition of the bidders, my lord.
Page.
Page 44.
Yes.
My lords, I won't trouble your lordship with the entire clause, my lords. But my lords, I have gone through the eligibility criteria, my lords, subject to what my learned friend says, my lords. It does not provide that you have to submit a Bakijai clearance certificate at the time of submission of the bids. Therefore, it is not a condition precedent for submission of the bids. Now, my lords would kindly turn to 5.1 D and E, my lords. What are the requirements as per the eligibility?
Yes.
Bidder should have paid arrears of dead rent, contract money, permit money in respect of lease, contract permit held by him, a notarized affidavit on ₹100, non-judicial stamp paper declaring the lease of major minor minerals held by him by the bidder in the state of Assam, and no mineral revenue dues to the government of Assam shall be submitted as part of technical bid on or before the due date. This affidavit must be sworn after the date of publication of the sale notice. E, bidder should not have been convicted of any offense involving moral turpitude or illegal mining. A notarized affidavit on ₹100 non-judicial stamp paper declaring that the person is not convicted in any criminal case shall be submitted as part of technical bid on or before the due date. The affidavit must be sworn after the date of publication of the sale notice. Now, my lords, the eligibility, and we suggest 2 affidavits. One, my lord, to put it in short, a no due certificate, or no due affidavit, that there is no mineral due on behalf of the contractor. And second, that he has not been convicted in any criminal offence. So these are the two affidavits which has been envisaged as the eligibility criteria, my lords. Now, clause 5.1D does not stipulate that along with the declaration, there has to be a Bakijai clearance certificate. Now, my lords, if my lords turn to page 75 of the bid document, that provides for the format. The affidavit referred to in 5.1D, the format is provided in page 75. Here, my lords, if my lord comes to paragraph 3, that I have no mineral revenue dues for any major and minor mineral in any forest division in the state of Assam, that I have also attached herewith my Bakijai clearance certificate to this effect. The affidavit provides, the format provides for affidavit, that there is a sentence, my lord, that I have also attached herewith my Bakijai clearance certificate to this effect. Now, admittedly, my lords, while preparing the affidavit, this line was inadvertently added because it was there in the format. However, my lords, in my humble submission, since Bakijai itself is not an eligibility criteria, such mistake has to be condoned. And in any case, my lord, if your lordship goes to the point number 5, it says affidavit not in format. Now, my lord, it's a catch-22 situation. Now, if I don't give the affidavit in the format, which has this, they would reject it. And if I give it, the requirement of Bakijai certificate itself is not there. Now, in any case, my lord, I'll refer to the judgment later. There's a judgment of the Honorable Division Bench of this High Court in a tender matter, which pertains to settlement of a fishery, where my lord's bids were rejected on the same ground that Bakijai certificate was not provided. Now, the Honorable Division Bench has clearly held that providing a Bakijai certificate is not an essential condition of, not an essential condition for a tender. It says it's a curable defect, my lord.
But
And that
after
was,
after the Supreme Court judgments which have now come in,
my lord,
how far,
I'll satisfy your lordship.
which will be binding, that you'll have to make your
Yes.
submissions.
Yes, I'll satisfy your lordship. Now, my lords, there is another judgment, my lords, which reiterates the stand, again a tender, auction, fishery tender matter, which is Bakijai certificate non-furnishing thereof is not a defect, is not a defect for which the tender is liable to be rejected. Now, my lords, the last ground, which is, my lord, page 19. 92, my lord. The last ground, the fourth ground, I'm so sorry, bid document not digitally signed. These are alien conditions, my lord. These conditions do not form part of the bid document. It's not even in the eligibility, my lords. It is not provided in the bid document at all. That all the documents annexed with the bid, the technical bid has to be digitally signed. Now, my lords, if my lords comes to
In
Page
this, there is a judgment of this bench on the point of digitally signature.
yes, ma'am.
Mr. Goswami would be knowing it.
Yes.
I'm carrying it. Anish.
You're carrying it. Okay.
Here, my lords, the format provides that along with the technical bid, there has to be a bid letter. And the format of the letter has been provided in the bid document. Format, if your lordship comes to page 66, lordship would find the format. Page 66 for a moment. the bid letter. The bid letter
68.
66, my lord, starts from 66.
Bid letter, yes.
Bid letter. I won't trouble your lordship with the entire my lord, clauses, but it does not say that the bid letter and the documents furnished therewith has to be digitally signature. But nonetheless, if my lord comes to page 84 for a moment, although there is no stipulation that the bid letter and the documents has to be digitally signed, but nonetheless, my lords, at page 84, my lords would find the bid letter, which was furnished along with the technical bid, my lords. The entire bid letter, which is as per format, has been digitally signed, my lord. My lord would see at the bottom, Avinash Nath, digitally signed by Avinash Nath, and also there is the physical signature. One, my lord, the entire bid letter has been digitally signed. Now, I would admit, my lords, the documents furnished along with the bid letter, although it was physically signed, countersigned each and every page, the documents, the annexures, were not digitally signature. But that is not a criteria, my lords. The entire bid document does not say that each and every page has to be digitally signed digitally, my lord. But the bid letter, the digital signature is there, all the pages. Now, my lords would come to page 49 for a moment, my lord. My lord would consider that even assuming that digital signature was
Because in order to understand this, I did an unprecedented act of going there, watching the Amtron people operate it and then show it to me. Because since technical things were there, I came to that side to see how they were interpreting that digital signature part. Because that is technical thing I am not aware. Therefore, I had to learn a lesson.
Well, I didn't venture deeper into the matter because it's not an eligibility criteria.
No, it's okay.
It would have been an eligibility criteria that each and every page has to be digitally signed. Then, of course, my lords. Now, my lords would come to page 49 for a moment. But this is just to show that even assuming, my lords, that digital signature was a necessary concomitant, my lords. So it was necessary. Whether the absence of the same would have resulted in dismissing or rejecting my technical bid, my lords. Page 49. Clause
No,
A.
because you see because you see, we come to page 32,
My lords.
it's an e-auction notice.
Yes.
So if it's not a digitally signed document,
Yes.
it's perhaps e-evaluation.
Exactly, my lord. I totally
might
understand.
not-
And hence, my lord, my bid letter, I have digitally signed, but the annexures are countersigned physically, but not digital signature. But that is not a eligibility criteria, what I'm trying to point out, my lord. And again, my lord, this would solve it, my lord. Page 49. That would perhaps answer my lord's question, my lord. Page 49. I mean, they cannot be so whimsical, my lords. Government revenue is in question. The less the competition, it would harm the government revenue. The flimsy grounds, my lords, they themselves say EPF and ESIC is not required. You furnish it after a month. I give a declaration, my lord. I'll come to that. That I'm not furnishing it now. I'll furnish it later, along with the technical bit. I'll come to that. So at page 49, my lords. A, first round of e-auction, Roman 2, my lords. Capital A, small a, Roman 2. Initial price offer shall be equal to greater. Lordship has it, my lord. The technical bid and the initial price offer must be electronically as provided in the schedule so and so, failing which technical bid shall be deemed to be not received. the duly executed original physical copy of the technical bid may be demanded by the authorities at the address specified in clause 13.1.2 anytime during the bid process. In case of differences between documents submitted electronically and original documents submitted physically, the original documents submitted physically shall prevail. Earnest money payment shall be made electronically according to details provided on the website. Now, this clause provides, my lords, so far what I've understood, that if there is any discrepancy or something, they can always call for the physical copy. And under such circumstances, the physical copy will prevail. Now, first, my lords, there is no criteria saying all pages have to digitally sign. Even, my lords, assuming that the annexures were not digitally signed, they could have taken recourse to this clause. Because after my technical bid is submitted, they open it, and on the day of opening it, the results are not declared. The results are declared later. Now, my lords, the last point, point number 5. I'm sorry, I'm referring to page 92 again and again, my lord. I'll read it out, my lord.
No, it's okay. No, it's okay. It's better because you're taking up points individually.
Yes.
No issue with that. Yes.
Point number 5, facts and affidavit not submitted as per format, hence rejected. Now, my lords, I have already shown, my lord, in the eligibility criteria, the 2 affidavits are envisaged. One is no dues and second is no conviction. These 2 are eligibility criteria which provide for the eligibility criteria. Those affidavit has to be there. There is another affidavit which has also been envisaged. If my lord comes to page 68 for a moment, my lord.
Yes.
Page 68, my lord. I'm so sorry, page 67, my lord. Page 67, last point.
Yes.
Along with the bid letter for technical bid, point 4, no mineral dues, they again reiterate that this affidavit has to be there, number 1. Next page, my lords, 6. Not convicted affidavit has to be there. And they add another affidavit there, my lords, which is not eligibility criteria, but nonetheless, it's an affidavit along with the bid letter I have to submit. Verification of facts and documents, affidavit. 3 affidavits, my lord. Now, my lords, would directly come to page 94. I have annexed the affidavits filed along with the technical bid, my lords. Page 94. It's an e-stamp, my lord, worth
Just-
100 rupees.
Just. Page number.
Page 94, my lords. All the 3 affidavits are annexed there. my lord. '94.
Yes.
My lord, see, it's an e-stamp, non-judicial 100 rupees as prescribed by the next page is the affidavit, my lords. This is the no due affidavit that I am a citizen of India, that I have no lease of any major or minor mineral state in the state of Assam. If yes, submit list. Yes, I have no mineral dues for any major or minor mineral in forest division in the state of Assam, that I have also attached here with my Bakijai certificate to this effect. That this affidavit is sworn for the sole purpose of submitting it before the authority concerned in order to prove the above mentioned facts. If my lord turns the page, the second affidavit, non-conviction affidavit, again on a stamp paper of rupees 100, duly notarized. I am the citizen of so and so, that I have not been convicted for any offense involving moral turpitude, criminal activity or illegal mining in the forest division anywhere in India, so and so forth, my lord. I won't read the entire. The last affidavit, my lord, again 100 rupees stamp paper. It's the third affidavit which is envisaged, my lord, that all documents, that the bidder has submitted all documents and verified himself up to his own satisfaction for participating in the auction. So all these affidavits, my lord, we have submitted as per the requirement, and in fact, they are as per the format provided by the forest department. Now, my lords, last, my lord, just one document, my lords, would come to page 93 for a moment, my lords. Because of the clarification issued by the forest department, while submitting my technical bid, I also give a declaration, which says, I, Shri Avinash Nath, son of so and so, aged about so and so, permanent resident so and so, do hereby declare that if the work allotted to me by concerned authority, I will provide it within 1 month. The heading says declaration for EPF and ESI. Now, the entire modus operandi will be clear by the next. Mohol settlements, my lords, always, my lords. Lordship would come to, my lords.
Because Mr. Manto, the only presumption I know is 100 what you call 14 E. You are aware of it?
Evidence Act, my lord.
All official and judicial acts are
Presumed to be.
are regularly performed.
There's a presumption. But I'll refer to a different kind of presumption.
Okay.
Page 56. The bid document. gives a-
56.
56.
Yes.
My lord, the bid document, it gives a timeline, my lords. Timeline that has to be followed. Not mandatory, my lords, but more or less it has to be followed. Timeline. My lord, to turn the page and come to, my lords, refer to point number 11, my lords.
Yes.
11, it says announcement of technically qualified bidders, stage 1.
Yes.
My lord, check the next column, the timeline. 3 days from the date of opening of the bids. Now, when the bids are opened by the forest department, within 3 days, they would announce the technically qualified bidders or people who had been technically rejected. Now, my lords, the rejection lordship would take note of the date.
Yes.
Rejection is dated 16/5/2023.
Opening is, what is the opening date?
Opening date is not there, my lord. My lord, I have to peruse the records. But if my lords come to page 92, I can show the date, my lords. Top left, my lords. It's 16/5/2023, 11:23 AM. Top left, my lords, page 92.
It is 15.
16/5/2023, 11:23 AM. So as per the timeline, the bids must have been opened 3 days prior to 16th. Now, again, my lord, page 57. Clause 12, my lord. Opening of IPO of technically qualified bidders and intimation to the qualified bidders only 2 days prior to live e-auction stage 2. And the tender is divided into 2 stages, my lord.
Yes.
All the initial bidders who apply for the technical bid, my lords, they would quote a price, an initial price offering. And after all the technically qualified bidders are declared, the highest quoted price would be the reserve price for the final auction. So final auction would start from the highest reserve price. Now it says opening of IPO, initial price offer would be after 2 days. After the announcement of technically qualified bidders, on that day itself, they would not open the price of those qualified bidders. They'll open it after 2 days. And next, announcement of highest bidder from stage 2 will be informed by the department within 2 days. Now, in the instant case, my lord, I was declared to be qualified, my lord, on 16th. So there was the declaration of qualified and unqualified bidders on 16/05/2023. Now, after 2 days, they ought to have opened the price of the qualified bidders after 2 days. But here what happens, my lord? On 18th, after not even 48 hours, they issue the letter of intent to the qualified bidder. That would mean, my lords, that they had opened the price offers, conducted a live e-auction within 24 hours. Now, my lords, why I'm pressing on this point, my lords, the Supreme Court has time and again held, my lords, if a matter is dealt with in a post-haste manner, there is presumption of malafide. My lords, I'll give the citation. I'm very sorry, my lord, I couldn't get the judgment, my lord. I'll give the citation. It's 2010 11 SCC 455. Now, in that matter, what had happened, my lord, allotment was done within 48 hours. The Supreme Court said, my lord, such an action, such post-haste manner is indicative of malafide and malice, my lord. Here in the instant case, on 15th, the petitioner, along with other persons who had, my lords, tendered for the auction, my lords, they gave a letter to the Chief Secretary saying what is happening. And we, my lords, especially my client, has already said that this tender is going to be settled in favor of the private respondent. Now they opened the tender. On 16, they declared the qualified bidders. Within 24 hours, they open the IPO, they conduct a live e-auction, whereas it is stated that 2 days time would be taken to open the IPO. Now, in my respectful submission, my lord, if such a recourse is taken, my lord, I have specifically stated in my writ petition that it would be against public interest, my lord. And I am not sure, my lord, but I have been told by my client, my learned friend appearing for the forest department would clarify. Because there was only a single bidder, my lord, who was technically qualified and he was settled with the tender within 24 hours. So, my lords, although the private respondent has been issued the letter of intent, my lords,
But then tell me, if there is only one bidder who is technically qualified, why there would be a what you call a live auction?
and
Person is not expected to compete against himself.
in fact, the bid document provides that if there is one technically qualified bidder, it has to be re-auctioned again twice. And on the third time, if it is again the same case, then that person has to be settled with the tender.
Where is that clause? Tell us after some time.
I'll
Meantime,
get that. But just one last point, my lord, that as of now, only the LOI has been issued, my lord. As per the tender document, a mere issuance of an LOI does not mean that he is the successful bidder. Because, my lord, everything is provided in page 53 onwards. There is a long process, my lord. First, he'll be a preferred bidder, and only upon fulfillment of certain conditions, like clearance certificates from the environment department and all, he'll be declared to be the successful bidder. So as on date, no right, absolute right has crystallized with respect to the respondent number 5. This is my point.
May kindly peruse page 47. Clause 5.2.9, that number is relevant. 5.2.9 at page 47. It mandates, my lord, scan copies of PF registration A, 5.2.9A, and then, my lord, ESI registration. Now, my lord, the petitioner has written a letter to the authorities at page 93, my lord. Declaration for EPF and ESI. I so and so, Assam do hereby declare that if the work allotted to me by the concerned authority, I will provide it within 1 month. In support of this, my lord, petitioner has also referred to a my lord, checklist that my lord finds at page 87, my lord.
Yes.
Either the petitioner is confused or my lord, he may be trying to make us confused. My lord. Page 87, my lord, will kindly see. It is the claim of the petitioner that this was the checklist provided to the petitioner along with the bid document, which is absolutely incorrect, my lord.
Page.
Page 87. Serial number 13 and 14. It says EPF certificate, if not available, same has to be provided within 1 month of being chosen as successful bidder as per clause 5.2.6 ESI certificate, next clause, my lord, ESI certificate, if not available, same has to be provided within 1 month of being chosen as successful bidder as per clause 5.2.6. My lord, my specific instruction is that, my lord, this time, my lord, in this bidding process, my lord, there was no checklist. And this checklist, my lord, pertains to a tender of 2018. That's why my lord will kindly take note of the clause. What is the clause number? It says, as per clause number 5.2.6, then as next also as per clause number 5.2.6. If now, my lord, again comes to page 47,
You are referring to where? 5.2.6, 14.
13 and 14, both, my lord.
Acha, 5.2.6, yes.
Says as per clause number so and so, you can provide it after 1 month of being chosen successful, my lord. 5.2.6. Now, if my lord comes to page 47, my lord, the requirement of enclosing those documents, my lord, in this tender process is at 5.2.9. He is referring to a, my lord, checklist of 2018, which, my lord, we have already discontinued, my lord, of this checklist. And if my lord peruses page 46, my lord, 5.2.6. Well, he is, my lord, petitioner is referring to a checklist. I don't know from where he has got it, my lord. It pertains to my specific instruction, my lord. This process, this checklist thing was, my lord, discontinued after 2018. Clause for page 46, clause 5.2.6 refers to, my lord, each bidder shall submit proof of purchase of the bid document on portal so and so, participation fee and earnest money amount to so. It has no connection whatsoever with, my lord, EPF and ESI registration, my lord. Which, my lord, finds at 5.2.9. So that argument cannot stand, my lord. Next, my lord will kindly see the affidavit at page, the format of affidavit, which forms part of the bidding document, my lord. He was aware, my lord.
Just a moment.
My lord.
Yes.
Well, page 75, my lord, is a format of the affidavit, which forms part of the bidding document. Petitioner was provided with, he was well aware. Page 75, serial number 3. The requirement was, my lord, that I have no mineral dues, revenue dues for any major or minor mineral in any forest division in the state of Assam. It is specific, my lord, that I have also attached here with my Pakistan certificate to this effect. If now, my lord, peruses his affidavit, my lord, what he has done, he has edited or, my lord, deleted that part of the affidavit at page 98, my lord. Serial number 2, that the bidder should have paid the arrears of dead rent, contract money, permit money in so and so held by him. Also, declaring the leases for minor and mineral, major and minor minerals held by the bidder in the state of Assam and no mineral revenue dues to the government of. This is a statement, my lord, he has added by deleting the requirement of annexing Bakizai certificate and making a declaration to that effect, which is not permitted to do, my lord. Then, if my lord peruses page 84, my lord. This was the forwarding letter of the petitioner.
I just had a idea. Now, do you have any dispute that the Guwahati High Court rules is mandatory
No, my lord.
or it is directory according to you?
For us, it is mandatory, my lord.
Mandatory. So now you see, if you come to chapter 5A, form for the writ petition, all the writ petitions are squarely not as per the form.
Exactly, my lord.
But can I start dismissing a writ petition just because
My
it
lord is
is?
exercising Article 226, my lord. We are the bidding authority, my lord. We'll
Okay.
go by strict interpretation because these officers may not be, my lord, using their discretion fairly, my lord.
Okay.
This,
This, the query that has fallen from your lordship has been answered by the Supreme Court. In tender matters, the discretion has been left by the Supreme Court on the authority. It can either strictly follow.
Or
The
interpret.
only eventuality in which it can relax is if the relaxation is uniformly applied to all tenderers. Otherwise, it has the option of following strictly. It was answered in G.J. Fernandez, 1990.
page 84, my lord, is the forwarding letter of the petitioner while submitting the bid. Only this letter is digitally signed. Rest of the documents, my lord, in the entire bidding, technical bid, there is not a single digital signature. Only the forwarding letter contains digital signature, that too at the bottom, whereas the requirement was at the top. Anyway, that will be too technical. But my lord, the rest of the technical bits are not digitally signed, my lord. Just a minute.
Yes.
Yes, my lord. Now, my lord, what has happened? In fact, on the same day, 3 tenders were concluded, my lord, finalized on 18/5, my lord. So there is a petition filed, all exactly identical ground, my lord. There also the bidder failed to provide documents, my lord. Court has issued notice, my lord. There is no interim order. And my lord has seen, my lord, 16/5 was a rejection date. Petitioner approached this court on 6/6, my lord, 6th of July. In the meantime, my lord, the successful bidder has already deposited mining plan. He has already deposited security money and the first keys. So any interim consideration, my lord, at this stage, my lord, nothing but the loss of the government revenue, my lord. In that case, my lord, this was the order passed. Exactly identical by the same division, by the same e-auction notice, my lord. And one
See,
paragraph,
For a petitioner
my lord.
to come to Mr. Mohanto, since he does not, normally in tender matters, he would not appear pro bono. Therefore, the petitioner will take some time to come.
But at least, my lord, petitioner should not have brought that, my lord, checklist of 2018, my lord.
Whatever.
That my lord should produce the records, my lord.
I'll definitely produce, my lord.
And the other statement.
The clause says
the affidavit has clearly
5.2.6
stated that
and he's relying on a clause of 5.2.9.
No, but he's made one strong point about that the hurriedness in which you had proceeded without adhering to a timeline. Why that should not be a ground to.
In fact, a different contractor has also applied the honorable court, my lord. He has also attached the same clarification. It was issued along with the bid document.
No,
Lordship-
that checklist doesn't form part of the bid.
All for the records, my lord.
We'll definitely produce the record.
In one day, they would settle the tender, my lord.
But if we don't do it, my lord, then people will say government is very slow. If we do fast, people will say government is corrupt.
No, but it is your own timeline.
Records will reveal, my lord. Records will reveal whether there was any malice in our action, my lord. So let notice go, my lord. We will react to his writ petition by filing an affidavit, producing records, my lord. But regarding interim order, my lord, I have some objections, my lord, because my lord, every time, my lord, an interim order is issued, my lord, government is losing revenue. There are almost 7-8 cases, my lord, wherein, my lord, for more than 2 years, my lord, we are not getting anything, my lord. My lord, one paragraph from a judgment, my lord. 2007-14 SCC 517. my lord.
2000.
7-14 SCC 517. The Jagdish Mandal case, my lord.
2000.
7, volume 14, SCC 517. 517. Paragraph would be, my lord, 22 months. This judgment was later on, my lord, followed in several decisions of an apex court, my lord.
What does it say?
It says, my lord, the judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether the choice or decision is made lawfully or not, to check whether the choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders or award of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to the award of contract is bona fide and in the public interest, the courts will not, in exercise of power of judicial review, interfere even if a procedural aberration or error is in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interests at the cost of public interest or to decide contractual disputes. The tenderer or contractor with a grievance can always seek damage in civil court. Attempts by unsuccessful tenderers with imaginary grievances, the checklist, would wounded pride and business rivalry to make out mountains out of a molehill of some technical stroke procedural violation or some prejudice to itself and persuade courts to interfere by exercising power of judicial review should be resisted. Such interferences, either in interim or final, may hold up and may increase the project cost manifold. Therefore, a court, before interfering in tender or contractual matter in exercise of power of judicial review, should pause to itself and the following question and to put the following questions: whether the process adopted or decision made by the authority is mala fide or intended to favor someone, or whether the process adopted and or decision made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached whether public interest is affected. If the answers are negative, there should be no interference. So, my only concern is, I am not concerned who is getting what, I am concerned what amount the government is getting. I will produce the records, let notice go, I will react. How will I say that?
I'll just supplement what my young friend has addressed your lordship on. The lordship has noticed from the submissions advanced by both these sides that there are 5 grounds on which he has been rejected. Even if one is sustained, it's enough to reject. Now, the lordship has seen that PF return and ESIC return, the checklist, the clauses mentioned do not even tally with the actual clauses in the tender documents. Now, Bakijai certificate, that has a twofold implication. It is admittedly, my lord, in the format that has been provided at page 75. That format is required to be followed. So that entails twofold disqualification. Number one, he did not follow the format. He edited it to suit his own purpose. Only because he does not have a Bakijai clearance certificate, he conveniently edits that portion and submits an affidavit. And as I said, madam, that has a twofold implication. First implication is you are not submitting the affidavit in format. And second implication is that the Bakijai clearance certificate, which finds mention in that affidavit, is not even there. Now, from what I could gather from my young friend Mr. Mohanta's submissions, is that the Bakijai certificate is not a requirement in the eligibility conditions. It is only mentioned in the affidavit. There, my lord, if your lordship will kindly have a look at the definition of bid document, which is provided at page 43. Page 42, your lordship will find that clause 2, the relevant terms are defined. At page 42, it starts, definitions, clause 2. And if your lordship kindly turns the page to clause 2.12.
Yes.
clause 2.12. Bidding document means this bidding document together with the schedules and documents referred herein, including the information memorandum and any addenda to this bidding document. So therefore, the format given forms part of the bidding document. The format of the affidavit that is included forms part of the bid documents, and there is non-compliance with the bidding requirements. Now, a lot has been said about the bidding process, how in a hurry it has been done. If you look, the evaluation criteria your lordship will find at clause 8, which your lordship, if your lordship kindly turns to page 49.
Yes.
The evaluation criteria is laid down in detail at clause 8. What is this whole process about? I'm not troubling your lordship with all the clauses. Your lordship will first come to subclause B, small b, towards the bottom. Third clause from bottom one. The technical bid shall be evaluated to ascertain compliance of the bidder with the eligibility conditions and requirements under this bidding document. So one of the first steps that the authorities take is to evaluate the technical bids, whether it conforms to the bidding document, and bidding document has been defined in clause 2.12. Now, immediately thereafter, my lord, there is a subclause 1 in that clause B. Your lordship will kindly note the first sentence there. Is received as per prescribed formats. It has to be in prescribed formats, along with all required documents and information on or before the stipulated date and time, failing which it may lead to disqualification. So this is exactly what has happened in this case. If you do not submit things in format, it entails a disqualification. That is what has happened. And thereafter, they proceeded. Now it is the petitioner's own case that after the technical evaluation process, there was only one tenderer left in the fray. So therefore, when technical bids were opened on 16th, when it was found that there was only one left in the fray, there was no question of a auction and bidding of one price, then counter offer by another one, another counter offer by another one. So there was no, that process naturally could have been curtailed. And that is how it happened in such a short time. And your lordship is aware, recently, this earlier concept of a single bid, in the event of a single bid, a fresh tender being invited, that has been done away with by CVC in 2022.
CVC, the government of Assam has not adopted it.
May not, but it is a guiding factor. In fact, there are judgments of our High Court where the CVC guidelines have been applied. There is a judgment, division bench judgment of 2003. I am forgetting the exact citation. Sargos Tours and Travels, where CVC guidelines were applied for adjudicating that case. It may not be strictly adopted, but CVC being a central agency, the guidelines prescribed can form a guiding factor. And even in this, the clause that might...
I would, despite the division bench observation, I may not go with it. If the state government has not adopted,
even under this very bidding process itself, what my learned friend was saying, that if there is only a single bid left, you have to mandatorily go for fresh auctions. That is not the case. The clause perhaps that my friend was referring to is at page 50. And the clause itself starts with the word normally. So that discretion is left to the authority. Page 50. Towards the middle, your lordship will find that clause that my learned friend was referring to. what it says is this one. Normally, if there are less than 2 technically qualified bidders, then the auction process shall be annulled, and such technically qualified bidder, if any, won't get a chance to proceed to second round of e-auction. However, if the auction is annulled on 2 consecutive occasions due to the same reason, that is less than 2 technically qualified bidders, then in the next e-auction of the say the single technically qualified venue shall be allowed to proceed to the next round of e-auction. So the whole clause starts with the word normally, so that there is an element of discretion left with the authorities. They may or may not. And this is perhaps on account of the fact it is not referred to. Perhaps this is a new CVC guidelines that has come in 2022, that the principles have been laid down that to go for retender, it entails more cost, more time consuming. So, so therefore, it is not always mandatory. The logic behind it is, if there has been an adequate publicity of the tender notice, there is no complaint that there was no publicity. If there is adequate publicity, all interested parties would have come. So therefore, my lord, in my respectful submission, your lordship will issue notice, allow us time to file affidavits. There is perhaps no question of interim order in this case. On 5 grounds, he has been rejected. And prima facie, it is clear that his rejection is, there is no error.
Okay. We'll just pass orders at 2 o'clock.
My lord.
এখন কাটবে হলুদ কালার রাহুল না
Submitted a my lord, bank guarantee in a different format. And Honorable Supreme Court held that, my lord, if it is duly prescribed, if the format is given in NIT, one will have to, my lord, submit the, my lord, the bank guarantee in that particular format only. And that will be a good ground for rejection. Now, my lord, if the petitioner has any grievance against the, my lord, superintending engineer or the executive engineer for not furnishing this particular certificate, despite, my lord, visiting the site, then, my lord, he ought to have, my lord, come before his honorable court or before the higher authorities before the last date of submission of bid, my lord. Here, my lord, the technical bid has been opened. Thereafter, the financial bid has been opened, and the letter of acceptance has also been issued as per the own statement made by the petition. And that apart, my lord, in the pre-bid meeting, my lord, the petitioner ought to have, my lord, taken a clarification from the authority in this regard, my lord, whether that particular photographs are required or not. The geo-tagged photograph is enclosed so and so. Because if the other bidders have submitted this particular, my lord, photographs, whether, my lord, the petitioner can be allowed, my lord, to participate, my lord, or be a, my lord, eligible or valid bidder without submitting this particular, my lord, document, along with this prescribed format, my lord, at page 130. Because it was within his knowledge that this particular photograph will be required.
When is the?
Page 130, 120.
No, 120.
120, that is a format,
No, not that. What I'm trying to ask you is that,
my lord.
you said there was a pre-bid meeting. When was it held?
Well, that will be in the date. The rules, right? My lord will find it at page 30. Pre-bid meeting on 25/5,
Just a moment. Page 30, you said.
page 30, 30.
Yes.
Serial number 3, my lord, it is written as 5. Pre-bid meeting 25/5/2023. Time has been given. So, my lord, if any bidder has any grievance or any, my lord, clarification is required to be sought for, well, on that particular date, my lord, in the pre-bid meeting, he can raise the issue. Then the authority will be bound to, my lord, reply that or clarify that. That opportunity was there, my lord. The petitioner did not avail it. On the contrary, he submitted a, my lord, certificate issued by the assistant executive engineer or in his individual capacity, my lord, no, not for, my lord, as per the format given in the NIT. And according to the petitioner, the letter of acceptance has been issued on 9/6
9/6.
in favor of respondent number 7.
But what about the other submission of Mr. Nath? That in the technical evaluation sheet, his
Well-
name doesn't appear.
Well,
In the technical evaluation sheet,
my lord,
Page
the name of the
244.
petitioner doesn't appear.
244 page.
oh, yes, but in the minutes, my lord.
Huh.
That part I have also checked, my lord. Why it has not been mentioned, my lord, I will have to see the instruction. But my lord, by this email, my lord, at page 245, the ground has been cited. And from the own documents, my lord, annexed to the writ petition, it is apparent that, my lord, this ground is valid otherwise.
Same restaurant number 3 has given.
Page 245. From the, my lord, certificate at page 130 of the writ petition, it appears that, my lord, the particular certificate submitted by the petitioner in compliance of the clause 7.2 is apparently, my lord, not in proper format and is not accompanied by that, my lord, photograph. Geotech photograph. And not only that, my lord, even for the sake of argument, my lord, if we hold that, my lord, this geotech picture is not required. Even then, my lord, that certificate is not in format and not issued by the competent authority. Petitioner, my lord, by submitting that, my lord, certificate which is not in format, 2K, my lord, sons, my lord, and now when he is not L1
No,
bidder,
but one more thing,
my lord,
this clause 7.2,
Page 45.
strategy study from the concerned executive engineer.
it is very specific, my lord.
Mr. Nath, you can't give a stay in the tender,
My lord.
but whatever work is being awarded shall be subject to further orders of the court.
My lord.
But Mr. M. Nath, the senior counsel, assisted by Mr. E. Roy, the counsel for the Mr. M. Nath, counsel, senior counsel, assisted by Mr. E. Roy, counsel for the petitioner. And Mr. B. Gogoi, and standing counsel for the
PWD.
PWD, appearing for respondent numbers
My lord, we have 1 to 6.
1 to
6
6.
is the evaluation committee of the tender.
Agreed by the rejection of the bid of the submitted by the petitioner during technical evaluation on under clause for non-compliance of clause 7.2 of the bid document The present writ petition has been filed under Article 226 of the Constitution of India. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Honorable Departmental Council within 2 days. Next, the petitioner shall take steps within 2 days for service of notice on respondent number 7 and 8 by registered post with AD. The learned instructing council is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next, heard both sides on the prayer for interim relief. The learned senior counsel for the petitioner has submitted that in clause 7.2 of the bid document, there is no mention that geotag picture certified by concerned executive engineer was required to be submitted. But the same has been inserted in the format of site visit certificate within bracket internal page 97 of the bid document. It is submitted that the executive engineer PWD, Gwalpara building circle
Yes, madam.
also is also holding the charge of superintending engineer PWD Gwalpara building circle. He'll be holding a charge, right?
Yes, in charge, you will be in charge.
He'll be
There
in
is no
charge.
proper executive engineer, and he took full advantage, to
No,
give
it's okay, but he'll be the in charge only.
Yes, yes, yes.
In charge. And therefore, the said authority is also the tendering authority. First, it is submitted that as he did not provide the concern, the requisite certificate, the petitioner is alleging malice and malafide, and accordingly has implemented the said executive engineer, executive oblique superintending engineer as respondent number 8 by name. Opposing the prayer for interim relief from the learned standing counsel for the PWD has submitted that prior to rejection of the bid of the petitioner during technical evaluation, the petitioner has never raised an objection that the concerned executive engineer PWD had not issued him a certificate together with certified picture of containing geotag to show site visit, and that the said certificate, which is and the certificate issued by the assistant executive engineer PWD on 29/5/2023 was in his personal capacity and not as per the prescribed format. Next paragraph. For the purpose of examining this matter for the prayer for interim relief, the court is inclined to accept the submissions made by the learned departmental counsel that prior to submitting of the bid and of the rejection of the bid during technical evaluation, the petitioner did not raise an objection that he was not being provided with a certificate. as per format. And internal page 97 of the document.
My lord, what happened? On that day, he didn't know that particular officer because bidding date of third till date, he didn't know he will not giving certificate. That's the reason. It's a simple thing. That's why he didn't ask whether that certificate. Because bidding date was till 3rd of June. So he thought that he will give the certificate. So PB didn't ask that, my lord. That question didn't arise at all on that day.
No, my lord, my submission was, my lord, that so far as the geotech photo is concerned, it is mentioned in the format, but it is not there in the principal clause, that is 7.2. That query he ought to have clarified, my lord, at the previous meeting.
That's
that
why it's not an
whether
essential condition.
It will be required or not, because in 7.2, there is no mention of geotech photo. But in the format, my lord, at page 97, internal page of the bid, my lord, bid
No, that is
document.
okay.
On that part I have submitted, my lord. That in the previous meeting, you ought to have raised this.
Accordingly, as the certificate is not found as per the format, the court does not find the petitioner to be entitled to any interim relief at this stage. Next fellow. Nonetheless, it is provided that the issuance of work order in this matter would be subject to further orders that may be passed on the next date. Next fellow. It is also provided that in the event an affidavit in opposition is not filed
Fine.
by the PWD, the authorities of the PWD shall provide the attorney standing counsel with the relevant record for being produced before the court. List after 4 weeks.
Any date?
Date I'm not
I'll
fixing
wait
right
my-
now.
my-
After 4 weeks, you make a mention, we'll give it. Because right now,
Yes.
so many matters being coming up after vacation.
Only because the ones that start works, what happens, my lord. Lordship knows, my lord. Because
understand.
ninth order was passed, 4 days, there is a lot of things to be done, but they have not completed that. That's why I don't think they've started the work. That's why, my lord. I'm obliged.
My lord, for your lordship, I think today is the day for adjudication of technical bids and how arbitrarily they were dealt with, my lord. I was listening to the other two cases, my lord. So far as irrationality, unreasonableness, my lord, this is the height of the case, my lord. My lord, it facts are slightly like this. I am a company, my lord. We are the manufacturer of liquid medical oxygen, LMO. And we have been successfully supplying this LMO to, my lord, various government hospitals all over the Northeast, Air Force Hospital, big private hospitals like GNRC, nursing homes in Assam and others. We have our distributors in Tripura and other northeastern states, my lord. And we also supply to 3-4 medical colleges of Assam. We have 2 plants for manufacturing of, my lord, liquid petroleum,
Liquid oxygen.
medical oxygen.
Yes.
One is at, my lord, Amingaon. And another, my lord, a plant as well as, my lord, storage facilities. Another in Bhutan, Sandruk Jankar. We have the requisite export as well as import license for importing this LMO from Bhutan and to supply it to elsewhere, including Northeast. But the Director Medical Education, DME, my lord, floated an e-tender under the official portal of Government of India, GEM, Government e-Marketing, which your lordship will find at page 22. Page 22. It was floated on 8th of May 2023. Bid end date 22nd of May. Bid opening date same day. Bid offer validity 180 days. Then below, my lord, documents required from the seller. All of documents. In this case, no problem with these documents. Then the next page, here's an important clause. Time allowed for technical clarifications during the technical evaluation, 3 days. So, my lord, after technical initial rejection on certain grounds, we
That
want,
that was which page?
page 23. Top.
Huh.
Time allowed for technical clarifications during technical evaluation, 3 days. Which means, my lord, after rejection on any ground, one is allowed clarification to give clarification, if any, sought for by the respondent authority. That means one is allowed to explain. Now, my lord, I submitted my bid, my lord, technical vis-a-vis, my lord, the price bid in time. Annexer D is our technical bid with all requisite documents, which your lordship will find it. My lord, there is another important clause which (28C). My lord, along with the bid documents, lordship, kindly here see, the technical specifications for supply is also mentioned at page 28. Has your lordship got it? Page 28.
Yes.
Technical, its headline is, my lord, technical specification for supply. Come to clause 2. Supplier has to maintain the stock for minimum of 15 days requirement after assessing the requirement before submission of bid. Notably, my lord, it does not specify the quantity or stock capacity. It just mentions that for 15 days. The specified quantity is mentioned below delivery locations. The bidder shall supply LMO in the following locations with required quantities mentioned below. My lord, these medical colleges, mostly to the medical colleges. The total quantum comes to, my lord, 42,800, 42,80,000. I have, my lord, did the bit of arithmetic. Total, your lordship may write 42,80,000.
Yes.
Now, my lord, here another important clause your lordship will be finding at page 29, the last clause. Both L1 and L2 vendors shall be eligible to supply at the L1 rates only in case of emergency exigency. Medical oxygen is always emergency and exigency related. Medical colleges are free to indent L2 parties at L1 rates. Rate of LMO quoted by the bidder OEM shall not be more than the NPPA capping rate. So these are the provisions, my lord, which will be relevant for my case. Now, my lord, two bidders. The annexer D at, my lord, page 30 is our technical bid. It goes to, my lord, from page 30 to page 35. Page 35. Page 35, lordship, kindly see, these are the list of documents we have enclosed. At serial number 3, production and storage capacity of LMO. So all the documents which are, my lord, required to be submitted, we submitted, my lord. I crave leave to produce the documents if necessary, my lord. Then what happened? And then the necessary security deposit. Thereafter, my lord, I was surprised to receive, my lord, a portal communication from the respondent authority dated 31/5/23, technical bid opening date, which your lordship will find at page 38. Page 38 is slightly blurred, therefore, my lord, I have annexed a type copy of it. at page 37, Lordship may straightway go to page 37. Now, I think I'll have to read it. This is the initial rejection and reasons for disqualifications. Here not mentioned, because status, they have given the status disqualified. I am technically disqualified. Reasons, other, it means reasons are not given. Comments are given, comments. I take them to be the reasons. If your lordship take, number 1, production capacity certificate per day metric ton of the LMO manufacturer and purity status of liquefied medical oxygen gas for hospital use duly signed by concerned authority not submitted. And number 2, self-certification about storage capacity in the unit is kg of the Amingaon storage unit and unauthorized letter from PSC / licensing authority. PSCO means my lord, Petroleum and Explosive Safety Organization. Lordship, kindly mark in between PESO, there is an oblique. So, disjunctive, your lordship will have to read either PESO, oblique, or licensing authority, not submitted as per this document. Supplier has to maintain the stock for minimum 15 days requirement after assessing the requirement before submission of bid. We did it, no problem with it. Then self-declaration of fulfilling the clause. There was a clause, the bidder must have experience of supplying. We meet it, no problem with this also. But not submitted, 300 bedded, we clarified it. So on all these 3 points, number 1 is that production capacity certificate not duly signed. Number 2, self-certification certified by us about storage capacity and authorized letter from PSCO / licensing authority not submitted. And number 3, we must have experience of supplying. We had the experience, my lord. 2 years experience was necessary minimum. Then we clarified, my lord, all 3 points. Annexure F, page 39. This is the representation. We were very categorical in our reply. Query number 1, you said production capacity certificate per day per metric ton of LMO manufacturer, purity status liquid oxygen gas, duly signed by concerned authority not submitted. Our reply. Our medical oxygen plant at Bhutan near Rangia, Assam in the name of so-and-so had production capacity of 40 metric ton per day along with storage capacity of so-and-so. We had already mentioned in the time of submission of bid and respective papers of storage tank uploaded along with production capacity certificate. Along with production capacity certificate, for your further clarification, the same documents were again uploaded for your further necessary action. Please note that PESO license is not required in Bhutan. And that was also, my lord, alternately required. PESO / licensing authority certificate. Here, my lord, the production capacity certificate, your lordship may kindly go to page 55 immediately. Then I will again come back to this. Annexure H. This is to confirm that the SD so-and-so limited has been approved as a FDI, foreign direct investment project in Bhutan for manufacture of cryogenic gas agencies. It is given by my lord Ministry of Industry, Commerce and Employment, Royal Government of Bhutan. The approval for manufacturing plant was accorded on 25th January 2019 based on the technical authorization for manufacturing of medical products issued by the Drug Regulatory Authority, Royal Bhutan Government. The TM is approval issued inclusive of manufacturing, establishing the premises, including installation of storage tanks in keeping with the good manufacturing practices. Similarly, the Department of Industry has approved the project as a package to construct, install storage tanks, so-and-so unit manufacture and export cryogenic gases, medical liquid oxygen, and liquid nitrogen. So this is the certificate. We annexed along with our, my lord, this, and we have again, my lord, given the chance to clarify. We have produced it. Then lordship may also come to page 41. Page 41. Page 41, the document.
Just one.
What is it?
But please come back to page 55.
Lordship. Lordship.
This capacity,
Yes,
the last paragraph says, similarly, the Department of Industry has approved the project as a package to construct so and so 40 TPD manufacture and so and so. So it is only an approval. Where is the manufacturing capacity?
my lord,
certificate?
this is storage tanks. This is storage tanks.
No, you see, to construct,
Yeah,
install. That
Yes.
means that is something in future.
maybe, my lord, we can expand. We can expand. We can expand. We can expand the capacity, my lord.
No, that is different. But you must have an existing facility. That is what I understand from the tender document.
Tender document, I am showed, my lord, what capacity this has got. 40 TPD.
No, it says to install. That is future tense.
Yes.
Approval is granting to install.
Yes.
Doesn't mean that installation has taken place.
No, this will be clear from my lord document.
Okay, okay. Okay.
Then lordship, kindly see page 41. Documents enclosed. Numbers at the serial number 1 itself, it is the production capacity document. This year lordship will have to read with page 35. We gave them the production and storage capacity at serial number Roman 3 of LMO,
Page.
page 35. For both plants, my lord, Bhutan plant and Amingaon plant, I'll come. Then lordship may again come back to page 39. Page 39. Here we have mentioned. Please note that our plant has 3 modes of production where we can increase the production of liquid oxygen as per demand of our customer. Unnecessarily, we don't, my lord, exceed a certain limit of production, my lord. If we don't get the supply orders, my lord, why I am telling you, lordship, this LMO has to be kept, stored, tanked at a temperature of minus 180 degrees centigrade. So it is not that, my lord, in a warehouse sort of a business that we keep goods for 2 months.
Okay.
I think I am clear. Then, my lord, come to query number 2. Self-certification, no, where I left our reply to 1, we hereby submit test reports of Pollution Laboratories Private Limited, NABL. This is government. About certification of liquefied medical oxygen, which is duly signed by concerned authority. Our purity of liquid medical oxidation is 99.76% as per IP 2018. There is
my lord, all in national guidelines. We also confirmed that we will submit analysis report of our purity at the time of supply of our tanker in each hospital. Then come to query number 2. Self-certification about storage capacity in kg. My lord, the unit is here, lordship, mine. The
But just a moment, I'm sorry to
Unit-
disturb you.
unit is kg, not TAB.
No, it's okay, just a moment. You see, I have not been able to follow you for a different reason.
Lordship.
Mr. Barbara, you see, this bid you have submitted,
Yes,
was a bid as a joint venture or it was a bid in individual capacity as Meghalaya
no, it is my lord, my company,
Oxygen?
as a company, my lord, registered under the company there.
So Meghalaya Oxygen Limited,
Yes,
correct?
yes,
No, please come to that certificate you were showing us.
yes.
That is to confirm about SD Cryogenics.
Yes,
So
that-
therefore,
That is the name, my lord. That is with the name. That is with the name, my lord. We are, my lord, producing in Bhutan.
no, then it's okay. But you see, if instead of X, it is the name of Y, that means that Y will have to be a constituent of X.
Yeah, it is, my lord.
Where do I find it?
I can show it, my lord. Right now, it is not with me. I can, my lord. There is no problem, and they have not found fault with that also. They have not found fault with that ultimately, rejection.
Okay.
Anyway, self-certification about storage capacity of in kg. Here, my lord, the per unit of measurement is kg, kilogram. Kg, it is not, my lord, what the Bhutan government certificate said, my lord, TMA. Now, just now, lordship was asking me, the unit was,
Page 55.
yes. Yes. Manufacturing, TMN, technical authorization for manufacturing, TAM. Below it is 40 TPD, my lord. Storage tanks, 40 TPD. That is a, my lord, different quantification, my lord. So far as this case is concerned, we are required to go by the kg. And that is where, my lord, ultimately our case, they have also handled. Self-certification about storage capacity in kg of the Amingaon storage unit and authorized letter from PISO licensing authority not submitted as per bid document. Supplier has to maintain this.
TPD can be converted into kg because TPD is ton per day. TPD is ton, TON, ton per day.
But anyway, the tendering authority, my lord, has been relying on this unit, my lord, kg. Also, and they ultimately found fault with kg storage. Self-certification about storage capacity in kg of the Amingaon storage unit and authorized letter from PESO licensing authority not submitted as per bid document. Then they quote unquote, my lord, this sentence from the tender bid document. Supplier has to maintain stock for 15 days requirement after assessing report. Then we replied, we hereby confirm that the storage capacity of Amingaon factory is 33,909 kg. We informed you that we have installed another storage tank at Amingaon factory. This is additional, my lord, of capacity of 50,000 kg. This tank was installed after submission of bid. But we already have the sufficient, my lord, capacity with the 33,900 capacity Amingaon factory. Then the last sentence, we hereby mention that we have an additional storage tank of our plant in Bhutan also with a capacity of 78 KL. This particular tank we can also use for storage of liquid medical oxygen. We attach here to the documents of tank for your kind cooperation. Please note that PESO license is not required in Bhutan. Here, my lord, lordship may have a look at page 43 document also. This is self-certification. They said self-certification was required. Meghalaya Oxygen Private Limited confirmed that we have storage capacity of 83,909 kg at Amingaon and 1,35,000 kg at Bhutan plant. The total, my lord, I have calculated is 2,18,909 kg aggregate. And we have given the details of the storage tanks. Hence, the second purported failure, as stated by respondent authority, is also, my lord, I submit is baseless and contrary to the records. Our total capacity is, my lord, 2,18,909 kg.
Storage capacity.
Yes. Lordship? No, my lord, our self-certification 83 plus 1,35,000 total comes to, my lord, 2,18,909 Lordship.
Page.
Page, my lord, at 43. And we have stated in a paragraph also. Here the total is 2,18,909 kg.
I'll just convert it. You see, in page 28, you say that your the total purchasing in a year would be 42,80,000 kilograms of oil. Oxygen.
Yes.
Correct.
Correct.
Now, if I convert it, if I divide it into per day, it would come to about 12,000
Very-
kilograms of oxygen.
Yes,
Correct.
15 days requirement.
No, it's okay. I'm just making a calculation. 12,000 per day
Yes.
into 15 days would be 12 into 15 would be 180. So 1,80,000.
We
So-
have far more.
No, not that. But if you go by your capacity or self certification,
Yes.
it is 1,35,000. It falls short.
No, but I mean now 83.909. Kindly have a look. Page 43. Page 43, first sentence. We have storage capacity of 83,909 kg at Amingaon and 1.35 lakh kg at Bhutan. This is what I was pointing. So these two comes to a total of,
But Bhutan is a different entity.
Lordship,
Bhutan is a different entity.
whereas we have import license, we can import, my lord. We are supplying everywhere, my lord, under import license. Otherwise, we cannot.
No, if you can show from the tender document that it is permissible, then it's okay. Otherwise, I don't find.
No, they are not opposing that it is imported from, they are not on the ground that rejection is not on the ground that we are importing it from Bhutan.
No. But the storage capacity must be determined on the basis of your entity.
Yes.
That I'm not finding it here.
Tender documents, my lord, I have stated. In the tender documents I have given, my lord. Total is 2,18,000. Tender documents. Serial number 3, production and storage capacity of LMO, my lord, documents. The third document, it will be there in the records also, my lord. We have given the production and storage capacity of both the plants. And we have stated in paragraph 11.
Okay.
We have stated in, my lord, paragraph, my lord, page 11, my lord, kindly see. Paragraph 13. That the petitioner begs to, this I'll come later on, my lord. Page, my lord, 13. Page
That is
13.
otherwise permissible. my
I'm sorry,
Seems
page
my lord
13,
from
paragraph
Page
16, my
26, it has been clarified. They
Which
can, my
one?
lord, being a distributor, they can, my lord, supply it, my lord, as a
Okay.
supplier.
Okay.
Page 26.
My lord, come to page 13.
He is accepting your statement. He's
No,
not
I
disputing.
know, my lord, I am thanking him. My lord, page 13. It is the detail, my lord. 83. 1000 and odd and 1.35 total comes to my lord 2018 909. Then lordship again come back to the third query how I made. Two I have explained. Third query how I made. I was reading, my lord. I finished reading page 39, my lord, dealing with query number 1 and query number 2. Next page, page 40. 3, query number 3. Self-declaration fulfilling the clause bidder must have experience of supplying minimum 1 government private hospital or minimum 300 bedded not submitted. We have our reply is like this. We have already informed and attached of your above queries in our respective bid. We again submit following information for your time period and necessary consideration. They overlooked. We are again submitting. We started our first supply of liquefied medical at COVID-19 steps down hospital at Umachal, Shillong, Meghalaya on 31/11/21 and is still continuing. Certificate of DHSS Meghalaya enclosed for your ready reference. In Meghalaya, all hospitals are supplying from this unit only. 2, our second supply was made to GNRC Hospital, North Guwahati, 2021 and still continue. Bed capacity is 300. Copy uploaded. We are also continuously supplying to Nazareth Hospital, Shillong. The bed is 370. Recently, we have supplied one of the major government hospital, that is 5 Air Force Hospital, Jorhat. Bed capacity above 410. 5. It is also mentioned that we are continuously supplying LMO to Manipur government and Arunachal government through our dealer Pharma Marketing from 2021. Still continue. Bed capacity is 1000. 6. Recently, we had supplied to one major government hospital, 151 base hospital, Bosista, Guwahati, from 19 April 22, 300 bed capacity. We hope that we have provided all the required information supporting documents as per your letter under reference. If you require further clarification in this cited matter, maybe please contact us on our email, market so and so, anticipating favorable responses. Now, my lord, refer to page 52. Now, page 52. They have yes. Declaration for experience in supply of LMO. Self-declaration, it wasn't required, my lord. We, so and so, hereby declare that we are well experienced in supply of LMO to various government private hospitals of minimum 300 bed and above. Supportive document certificate at page 50. Supporting document at page 50. One certificate. Then second certificate. This is a certificate given by the GNRC Hospital Authority. Second one was by, that is not necessary. So, after all these clarifications we have given, my lord, they have not rejected on any of these grounds. They have jumped into a new pretext. Not this self-certificate, we have not furnished this self-certification, production capacity. After this reply, since they were hell-bent to favor the other than the private respondent, my lord, they jumped into a new ground of rejection, my lord, which your lordship will find at page 54. This is the ultimate rejection. Annexure G. The earlier preliminary rejection, initial rejection, I drew the attention of your lordship that no response description was given, the ground was not given. It is written, representation responded. 3/6/23. So on 3rd of June, the representation, my lord, top right side, it is written, my lord, representation initiated by me on 31st, immediately on receipt of the first preliminary rejection. This is the reason given by them. Response description. The current storage capacity on the day of submission of bid is much lower than the required capacity for 15 days. The estimated annual requirement for all the medical college hospital of Assam is 50,000 kg for 15 days. Quantity is 205479.45. Lordship may note it. But the licensed storage capacity of ML is 33,000 as on bid submission date. Even if the additional storage of 50 kg submitted by AES, the total storage capacity is less than this. Is, my lord, absolutely contrary to records, perverse, my lord. It is baseless. We have the capacity of 2,18,909 kg, and assuming that what requirement you are figure you are giving for 15 days requirement is all right, it is 2,05,479. Let's make a small note. Our aggregate capacity is 2,18,909. By this impugn communication, though they have given a far inflated requirement, which is not part of the tender, I'll show it. Even then, this requirement as shown by them, 205479.45 kg, can well be within our capacity, obviously within our capacity.
Yes, Mr. Goy.
That's why I am not finished. Just one second. I must say, before paying for something, my lord, I must say there are two things clear. Just 3 minutes, my lord. Lordship, bear with me. There is no way that on vital ground the authority could have rejected my tender. And my lord, the 30 years have gone past, my lord. The Tata Cellular case, my lord, and subsequent cases following it, my lord, is clear case of erroneous decision making process, and my lord, Wensbury unreasonableness and 226. It is a case of bias and favoritism, which is, my lord, and favoritism, which is, my lord, crystal clear. In this case, let me place before you some concrete elements of bias and privatization. My lord, bias is a word, my lord, easier said than established. I have, my lord. Kindly turn to page 56, last year's NIT. This very private respondent was page 56. This is the last year's, my lord, 8/2/22. Similar, same supply, my lord. Which says, my lord, and this private respondent of the instant case was allotted with the contract. It was a contract for 1 year. 1/4/22 to 31/3/23. Lordship, may make a note of it, my lord. I have stated clearly, and it is a 1 year contract. Now, it was very much within the knowledge of this director that last year's contract tenure was to expire on 31/3/23. Having known that they ought to have floated a tender well before the last date of expiry. They didn't. 31st of March, The private respondents' 1-year contract was to end. At least by December 22, they ought to have floated a tender. For mischievous reason, this director didn't do it. Why? Out of the law, my lord, they gave indefinite extension to him. R5 till today he is supplying. No short tender, no ad hoc tender. I have categorically stated, my lord. Can there be a, would your lordship require far more example than what bias and favoritism could be than this case, my lord? Can it happen? They didn't float tender. February, they floated a tender. They knew that by 31st March this year, they would come to an end. They didn't float the tender, my lord, well before expiry of the period. They gave extension. There is no provision for extension, my lord, under the bid document, under the NIT. Last year's NIT also I have annexed. No provision by way of even a whisper that in emergent situation, instead of floating tender, one can be given extension. It has been done. Just to accommodate.
Let me hear Mr. Gogoi. Will you hear Mr. Gogoi?
My lord, I will say what could be the prayer, because it is not, my lords, it is not, my lord, non-perishable goods or any other goods or forest produce. It is life-saving drug. The supply must continue. I must be reasonable in making such a prayer. Therefore, my lord, my prayer is, LMO is a crucial life-saving, as your lordship knows. Hence, there is a provision in the terms and conditions. I forgot to, my lordship, kindly see clause 10. Just 1 minute, my lord. I am concluding. Page 29, my lord. Page 29, my lord. Clause 10. In the tender terms and condition, there is always a, my lord, provision.
Yes.
Both L1 and L2 vendors, in this case, there were only 2 tenders, the private respondent and me. My technical bid, as I have said, in the manner was rejected. Both L1 and L2 vendors shall be eligible for supply at the L1 rates only in case of emergency, exigency. Exigency is always there, even now. SOP is going on. Medical colleges are free to indent L2 parties at L1 parties, L1 rates. Why? Rate of LMA quoted by not more than a. Why? Because, my lord, in a crucial supply line like liquefied oxygen, suppose by act of God, the plant and machinery of one supplier breaks down for 10 days, what would happen to thousands of patients? There should always be a, my lord, backup mechanism, like the backup generator we are having here. They never go for it. Last year they allotted him. I also
No,
competed.
once you're technically rejected, we can't give a direction to make a supply to you. That will be creating a contract
No,
by the court. That can't happen.
I can update. Therefore, my prayer will be, my lord.
We have seen your prayer. Your prayer is not to
No, my
give
lord,
effect to that.
No, that
tender.
is the normal prayer, my lord. My prayer will be, my lord.
Hmm.
Lordship will issue a notice call for the records, number 1. And lordship may give observations about the manner in which, my lord, my technical bid was rejected, and allow them to revisit my technical bid in the meanwhile. I am not saying that your lordship will.
Let me hear Mr. Gogoi
Yes,
first.
no, let me finish my prayer. What my prayer will be.
No, no, it's okay, Mr. Barbara. You have said had your say. Let me hear him and proceed. This is a motion matter. We are not hearing it.
Lordship,
Uh,
my lord.
Lordship, may kindly turn to page 38 for a moment, madam. They have annexed one document. This is from the, it is a downloaded copy from the web portal, my lord. Lordship may see, my lord, here at the top. The entire page has not been, my lord, annexed. Since, my lord, it is a technical evaluation before the rows and columns, my lord. It is a technical evaluation, then the evaluation history. Then lordship will see the status. Petitioner has submitted that this is his, my lord, technical evaluation
Where is that
report.
status?
My lord, in the below, my lord, evaluation history,
Yes.
status disqualified. Now lordship's comment. Comment here we can take it as remarks. 3 grounds have been given why, my lord, he has been disqualified. Now lordship may kindly turn to page
Just one,
37.
where's the disqualified status? Okay.
Now comments, my lord, they have given a type copy. It will be more convenient if your lordship look at page 37. The comment number 1, production capacity certificate per day so and so. Lordship will see the last line. Authority not submitted. Certificate was to be submitted. It has not been submitted by the bidder. Second, my lord, self certification about storage capacity so and so. In Amingao storage unit and authorized letter from so and so not submitted. Lordship will only kindly have a note of this particular, my lord. Even, my lord, the second document has not been submitted. Third point, self-declaration of fulfilling the clause so and so not submitted. So 3 documents, my lord, petitioner has not submitted. And for this, for that reason, my lord, the petitioner has been held to be disqualified by the technical bid evaluation committee. Now, my lord, a statement has been made by the petitioners that, my lord, this particular document at page 38 is a document whereby the authorities have sought for some clarification from the petitioner. But, my lord, prima facie, my lord, by going through this particular document, it appears, my lord, it is a final decision of the technical bid evaluation committee, which has been published in the uploaded in the web portal, whereby he has been declared to be disqualified. And it is not a document, my lord, whereby a clarification has been sought from him. Now, lordship will see, my lord, that particular clause that has been pointed out by the petitioner, that there is a provision for clarification at page 23.
Yes.
At the top, my lord, time allowed for technical clarification during technical evaluation. The word is, my lord, during technical evaluation, not after the technical evaluation. My lord, the reports are already published. Any clarification will have to be during the technical evaluation only, my lord. And this document at page 38 is a, my lord, document whereby the technical evaluation process is over and the petitioner has been held to be disqualified. Now, my lord, rightly or wrongly, the petitioner submitted a
Just a moment. Yes.
Now, lordship, I can turn to page 39. According to the petitioner, this is the clarification he has submitted before the tendering authority. Lordship, you see the subject. It is dated, my lord, 31st of May 2023. Subject is representation against disqualification. It's not a clarification, my lord. After being disqualified, the petitioner submitted a representation. Now, my lord, lordship will see, my lord, here they have indicated query number 1. This query number 1 that they have indicated is the comment number 1 of the disqualification, my lord. Lordship, Lord, I have already placed it, my lord, their own type copy. It's a comment, my lord. There's a remark why he has been disqualified. It's not a query, my lord. Now he replies, and in the query number 1, in his reply, in the second para, Lordship may kindly see, last second para.
Yes.
Lordship will see the last second para of my lord, of his reply to query number 1. Here he says, we hereby submit test report. Now, my lord, after the my lord, technical evaluation bid is over, the results have been declared. He now submits a my lord, certificate, which is not permissible. My lord. By my lord, this particular representation, by submitting certificates now, he cannot, my lord, overcome the shortcomings in his my lord, technical bid. Same manner, my lord, query number 2, the reply continues. Lordship may kindly down to page 40. Again, my lord, that our self certificate is enclosed. And for non-enclosing this particular certificate along with the bid document, his bid has been already rejected. After rejection, he cannot now submit. And my lord, pray before this honorable court that my lord, his bid is valid. His own admission that he has not submitted. It's not his case that my lord, he submitted, despite that my lord, the authorities have rejected his bid. And third query, my lord, some additional information has now been furnished to the tendering authority. So, my lord, by this particular representation, he may submit, my lord, several representation before the authorities, but he cannot, my lord, subsequent to the declaration of the result of the technical evaluation bid, my lord, he cannot, my lord, by supplementing his, my lord, by these documents, he cannot, my lord, pray before his honorable court that his bid is valid. He is already out on 31, my lord, 5. Now, my lord, this particular document, my lord, once another document has been annexed to the writ petition at page 54. Lordship will see here, my lord. '54 at the top. It is a not a, my lord, decision of some decision of the, my lord, technical evaluation committee. At the heading, it says, my lord, representation history. Page 54. At the extreme, my lord, right on the top, my lord, the date is given 31/5/2023. That is the date of his submission of representation. Now, lordship, in the column representation, Celine's description. It says, my lord, we hereby submit our representation for consideration of our bid regarding supply of so and so. So this is a representation submitted by the petitioner in this particular format on 31 in the e-portal on 31/5/2023. Now here in the bottom, my lord, response description. Well, in response to this particular representation, this is a particular, my lord, comment given by the tendering authority. But this is not a, my lord, disqualification. He is already disqualified on 31/5. It is a response to his representation. The petitioner is on a misconception then, my lord, by submitting the representation, he can now be, my lord, held to be valid. And that, my lord, documented page 38 is not a, my lord, document by which, my lord, some clarification was sought for from the writ petitioner. This is what I can find from this particular, my lord, document that has been annexed to the writ petition. So, my lord, so placing before this honorable court these technicalities, what he has, my lord, where he has got the factories and all, what is his capacity. That is, my lord, of course, not the lookout of the honorable court, my lord. He will have to, my lord, confine his entire pleadings or the arguments to the, my lord, this particular disqualification at page 38. Whether he has submitted his documents or not, my lord, along with bid documents. That is, my lord, the simple case here in that.
My lord, all right. Let us not be confused by the dates and what representation or my lord, it was a clarification. My lord, lordship kindly turn to the, I have already referred to, let us not be confused about the dates. My lord, the bid document, page 22. Nothing is decided on confusion. Page 23 column. Time allowed for technical clarification during technical evolution. 3 days. That means technical clarification during technical evaluation. Technical evaluation, the incumbents are there, my lord. They gave 3 reasons. Kindly see the date. Kindly see the date of their rejection. This one. Page 37, 38 is the my lord original. Type copy is at page 30. Type copy of relevant portal notification rejection notice dated 31/5/2003. So now come to this. One is always allowed for technical clarification. One gets 3 days time. I, my lord, immediately gave on 31st. Lordship, kindly turn to page 39. See the date. See the date.
Yes.
May 31, same day. The word may be representation. Representation against disqualification. And this is the, my lord, way I gave all the clarifications, my lord. Your query number 1, my reply is this. Your query number 2, my reply is this. And I referred to various documents. I even resubmitted documents which was already submitted. Records will reveal. Then page 40. One more document, my lord, I want to show. It is not that, my lord, it is a representation subsequent to everything is over. Your 31 communication said 3 things which are different from the ultimate pretext on which you rejected my tender on 3/6. Kindly their processing, kindly have a look at the processing of my representation by them. Yes. Page 54. Page 54.
Yes, I'm there.
Top right, representation initiated 31/5/2023, same day. I cannot be prompter enough. When you said e-portal notification stating 3 grounds, 1, 2, 3, I replied and clarified all 3 grounds on the same day. They have processed it after 3 days. Below, representation responded by them on 3rd June. So let us not be confused about the dates. Yes, what is representation? Representation in protest against your debt tree. So therefore, my lord, one more important document my lord, forgot to mention, which your lordship will find at page
42, 44,
42, 43, 44. Production capacity.
capacity 51,
No, 42.
42, but no,
দেখুন, দেখুন,
position level.
দেখুন। এর থেকে দেখো, এই
Eight.
page 50.